shall be heard. Please take seats.
Good afternoon, everybody, and welcome to the Appellate Division First Department. Nice to see everybody in the courtroom today. So I am going to call the calendar since I know that many of the attorneys are not physically in the courtroom. I'm just going to call the calendar and give out the times, and then we'll start with the first case. So the first case on the calendar is People versus Oscar Sanders. The appellant has 6 minutes and 2 for rebuttal. The respondent has 6. The next one is Eduardo versus Webster Equities. The appellant has 5 minutes and 2 in rebuttal, and the respondent has 4. W. Kevin, the appellant has 4 minutes and 2 in rebuttal, and both the respondent, attorney for the child, and the respondent ACS has 4 minutes each. Not sure if you'll both need that, but I'll let you guys work that out. Schmidt-Sarosi versus Offices for Fertility. Appellant has 6 and 2. The respondent has 6. People versus Thomas Romero is submitted. Tershwell versus TCW Group. The appellant, Tershwell, has 7 minutes and 2 in rebuttal. TCW Group has 7 and 2, and Ravitch has 7 and 2, because everybody's an appellant or cross-appellant in that case. People versus Harry Paul is submitted. Grandelli versus the City of New York. The appellant has 5 minutes and 2 in rebuttal. The respondents, Hudson River and Home Depot, each have 4 minutes. Again, after reading the papers, I see you really have the same position, so perhaps if you're hearing me someplace in the building, maybe you can get together and cut that down a little bit for us. Hernandez versus 767 Fifth Partners is submitted. Bowen versus Cone Resnick. The appellant has 7 minutes and 2 for rebuttal. The respondent has 7. Rivera versus O'Neill. The appellant has 5 minutes and 2 in rebuttal. The respondent has 5. CIPGP versus Koplowitz. The appellant has 7 and 2. The respondents have 8 and 3, and the other respondent, Eastmore, has 3 minutes together. The next case is Max versus ALP. That is submitted. People versus Shlomo Avraham. That is submitted. Taylor versus Behavioral Solutions is submitted. And Baldea versus City of New York license is submitted. So we will start with the first case, People versus Oscar Sanders. Okay. Good afternoon, counsel. You may begin.
Good afternoon, Your Honors, and may it please the Court. Alex Bistrin from Davis Polk, pro bono counsel with the Legal Aid Society, appearing on behalf of defendant appellant Oscar Sanders. On the attempted assault in the first-degree conviction, the jury did not hear legally sufficient evidence that defendant had the specific intent to permanently and seriously disfigure the complainant. This offense requires evidence that shows something more than an intent to cut or even to cause serious physical injury. The record must prove that defendant intended to cause the unique and emotionally shocking injury of disfigurement. This intent to disfigure is deemed as such an aggravating element that for this particular first-degree assault offense, there is no requirement that the defendant have use of a dangerous instrument. So the evidence here does not support this required finding. The circumstances show nothing more than a routine street brawl with both parties throwing punches all over. There is no reason or motive as to why...
Counsel, couldn't the jury find from the complainant's statements that he felt a sharp object being brought across his face? And wouldn't you agree, that's one question. The second question is, wouldn't you agree that if a sharp object is brought across your face, that is like the epitome of disfigurement?
Your Honor, not every knife fight or blade fight involves an intent to disfigure. The use of a blade may indicate an intent to cut or even to cause injury, but this particular offense requires an intent to disfigure, which requires something more. Additional circumstances such as motive, threat, exclusive focus on the front of the face, none of which exists here. And so when we also look at why there's no reason or motive for why this defendant would have had any desire to seek lasting disfigurement, there was no meaningful prior relationship between the two men.
No reason to believe he had any motive?
Yeah, there's no reason to believe that the defendant here had any motive to. Exactly, we do not need motive, but to show an intent, to show any intent, in particular an intent to disfigure in a case where it's not completed, involves an attempted offense, you have to look to the totality of the circumstances. And here, what I'm saying is.
We have here a 4-centimeter cut from the temple, which is the temple is in the front of the face, right? On the victim's face, a 4-inch cut down the front of the face, leaving a scar.
Yep, I would clarify that, and we included an exhibit in our opening brief that the complainant did sustain a 1.5-inch, 4-inch centimeter laceration on the right temple along the hairline. There was no laceration on the front of the face, and in fact.
The right temple and the hairline. And well, that may not be the front like that of the face, but it's certainly a part of the face that is visible to casual observers.
Yes.
I mean, you included pictures. There were pictures included in the record, so we were able to see the cut.
The cut.
Yes.
And yes, and so what we have here is just the cut. We do not have, the injury itself is the injury that we have is a far cry from disfigurement.
Well, you know, the other thing you said before was that there was no motive, and even though you didn't have to prove motive, you're looking at the totality of the circumstances. But isn't it true then in this case, there was a relationship between these various people? They met in a schoolyard at one of the children's, I think it was his 5th grade high school graduation, and there was some kind of maybe who wanted to go out to dinner, who had a gift. So there was some kind of interrelationship amongst these people. They weren't strangers in the night.
Yeah, the defendant was aware of the complainant, but prior to this incident, they never had any meaningful communication. The defendant never threatened him, acted violently towards him, and the people's theory here is that the defendant had a scalpel blade in his hat when he came to the graduation. So he did not procure any blade in response to any altercation that might have happened at the graduation.
No, he just generally carried around with him this dangerous instrument.
So turning to the.
Is that what you're arguing? He didn't get it there, he just carried it with him all the time?
So to the extent that we're looking at the existence of the blade at the time of the incident, to suggest that he had an intent to disfigure based on any situation that might have arisen with the complainant at the graduation, what we're saying is that that blade was not procured in response to any incident with the defendant. So while the defendant may have had an intent to cut or cause injury, that's entirely separate from whether he had an intent to disfigure. And again, you need.
You're really dancing around my question.
Apologies. And so if I may turn to our second argument, which is that the trial court erred in denying a lesser included offense charge. Assault 3 without a dangerous instrument here was warranted because a reasonable view existed that defendant injured the complainant by means of a nugget ring rather than a scalpel blade. The evidence here shows that defendant was wearing a diamond-studded ring on his fist, and the complainant believed that defendant was hitting him with a ring. This theory is consistent with the medical evidence. And I see that my time is up, and so I'll reserve the rest of the time for rebuttal.
We'll save those questions to ask you during your rebuttal. You have a few minutes at that time. Okay, thank you very much.
May it please the court, Luis Morales for respondent. If I may just clean up one thing with respect to the intent, in terms of a pre-existing relationship, there was not just a pre-existing relationship, it was fairly intimate in that, it goes back to the beginning of the relationship with the boy's mother, and other incidences that preceded the attack itself, the throwing of the money, the attempted humiliation in the front of the school, or the humiliation, as I should say, in front of the school, and that the injury, counsel described as a far cry from serious disfigurement. That was fortunate because a good Samaritan, a paraprofessional, intervened at the after one of the teachers noted the possibility for some violence at the time. And with serious disfigurement, the jury will typically have to draw some inferences. I don't think that's a particularly controversial proposition, as it's not common for someone to specifically enunciate their intent, I'm going to slash you in the face and disfigure you, but rather to look at the words, the actions, and so forth.
Counsel, what about the argument that appellant's counsel didn't really get to go into, that there's no evidence that a blade was used here, that it could have been the ring or something else?
Well, that sort of straddles both the intent and the lesser included. So I'll address it as to both, or one in particular if you prefer. But
Go ahead.
I think the evidence begins with the forensic testimony, the sharp force expert who describes a sharp, clean, smooth margins in describing the injury itself, intact and continuous line. And in terms of, we're not disputing that the scalpel was never recovered. We have the testimony with respect to his secreting it under his hat sticker in a prior instance. But to put it plainly, people are punched all the time in the face, and punched in the face even with rings, and that doesn't leave this specific type of injury. The expert went on to discuss, a blunt impact or split injury, the type that would be associated with a punch from a fist with a ring. So not only does the record lack a basis both for the charge, but it's actually inconsistent with the undisputable medical evidence, and that falls short of the rational basis standard in that respect. I know you have more questions of counsel on those issues, or if there is one of the other issues you would like me to get into in particular.
Counsel, the court, on the persistent felony offender question, the court did not issue a notice, correct?
That is correct, Your Honor.
And it did not specify why the defendant could qualify.
In its decision, it did, Your Honor. After the persistent felony statement was filed by the prosecution, admittedly, 2.5 months before the sentencing itself, there was a hearing.
Did that give the defendant sufficient notice ahead of the hearing about why he might be subject to that enhancement?
Yes, Your Honor, and there are several reasons why. First of all, it was well in excess of the 20 days specified in the statute, but beyond that, counsel was able to file, not only to address these orally, but he filed a preceding 19-page response, point by point, articulating his objections to that designation, which was, and there was no surprise, there were no new arguments, and in fact, when you look at it, counsel even now isn't suggesting that he needed more time. And so, the substantial compliance here is sufficient to meet with the statutory requirements.
Does anybody have any further questions? Do you want to bring up any other points, or do you want to just rest on your brief?
If the panel has enough, I'm happy to, it's a large brief, there are a lot of issues in a short amount of time, but if the panel doesn't have any specific questions, I'm happy to rest on the brief and ask that you affirm.
Okay. Thank you very, very much.
Thank you, Your Honor. Your Honors.
Okay, counsel, so you were getting into the lesser included offense, which Judge Mendez asked a question about that, and counsel spoke a little bit about. But how can you say that there is, it appears that there would be no reasonable view of the evidence that would support a finding that the defendant caused the complainant's injury with anything other than a knife.
Sharp
And
object.
The ring, the testimony about the ring and the uncontroverted medical testimony seems to be that the injury that was left on his face, which we saw from the pictures in the record, did not seem to be injuries, but that would be obtained by punching somebody in the face or hitting them some other way with a ring, but rather a very straight line. That's what it appeared, but forget about what it appeared to me. That's what the medical testimony was. So, how do you address that?
Yeah. The medical testimony here only supported that the injury was caused by a sharp object. So the question is whether there's a reasonable view that another sharp object other than a blade might have caused the injury here. And so the theory...
The testimony is that the cut was clean and neat. It was a cut that's made by something very sharp.
Mhm. Yeah.
Not by just a ring, or unless you're alleging that your client's ring had a knife in it.
So again, the medical testimony was just that it was something sharp and that it caused this straight long line as you're referring to. But the defendant testified that he was wearing a nugget ring that had 6 diamonds on it. And so those diamonds could have caused, there was a reasonable view that those would have been sharp, and that's entirely consistent with the medical testimony that if it was on his fist and it was being brought down along his temple, that would have been a cut. And that is
It would have been a cut, but it could have been a jagged cut as opposed to a clean cut.
there is no medical testimony that excludes the possibility of a ring and that it had to limit it to a scalpel blade. It was that could only be caused by a sharp object, and the question is whether there's a reasonable view that a diamond-studded ring is a sharp object. And just one other note on that is that
To me, it is absolutely bizarre that you are arguing that your client wore a ring that is capable of creating the injury that the complaining witness suffered here. If that's what he had all the time on him?
that
That is capable of causing that kind of an injury?
that in the course of, and again, we look at this from the view, in this context, the most favorable to the defendant. And so if on this instance,
To me, that's not favorable to the defendant at all.
understood, but that if he had a ring and that the ring was a nugget ring with diamonds on it, that there's a reasonable view that that would be sharp, and so that when you're punching someone with your fist and it's sliding down the head,
What you're saying is that your client walked around all the time with a dangerous instrument.
whether something's a dangerous instrument is a question of fact for the jury. And so whether or not this ring qualifies as a dangerous instrument would have been for a question for the jury. And if they deemed it not to be, then third-degree assault without a dangerous instrument would have been an appropriate jury charge.
I think you understood my question.
Okay, anything further? Okay, Mr. Bistrin, you introduced yourself that you're an attorney with Davis Polk, so you're doing this argument and this work on behalf of the defendant appellant as pro bono, is that correct?
That's correct.
So we would like to thank you for your time and your hard work, and please thank your colleagues at Davis Polk for letting you to do this pro bono work and assist us. Thank you very much.
Absolutely.
And
Thank you, Your Honors.
Thank you, and have a nice afternoon. Okay. The next case will be Eduardo versus Webster Equities.
Good afternoon, Your Honors.
Good afternoon.
May it please the court, Red Friedman for appellant. I will try to be fast here. I see two big problems with the motion that defendants made. The first is that they never actually conclusively showed what the weather conditions in the Bronx were leading up to the accident.
Put in any expert testimony as to the conditions involved?
I'm sorry, I'm having just a little bit of trouble hearing you, Your Honor.
Did you put in any expert testimony as to the conditions in the Bronx?
Plaintiff did not put any expert testimony of his own in, and obviously we're taking the position that we didn't have to because defendants never met their burden. One reason being that, as you can see, it appears our experts submitted weather data from most counties other than the Bronx, with the closest location being 6 miles away. The second problem is, even if you do look at those records, which I don't think you should, they show that there was essentially no significant winter storm for hours and hours leading up to this 1 a.m.
But counsel, did the plaintiff himself concede that it had snowed until about 8 o'clock on the 15th?
The plaintiff himself did not testify as to when it stopped snowing. The extent of his testimony was that he went to a friend's house, give or take 3.5 hours before the accident, and that it was not snowing then. He was asked at a few other points close to the accident, was it snowing? No. And defendant's own store manager was asked, was it snowing at the time of the accident? No. When had it last snowed? And he said, I actually think it just rained that day.
But he had to clear snow. He had a friend clear snow, and he himself cleared snow from the front of the bodega until at about 11 o'clock, according to his testimony.
According to his testimony, his friend cleared snow at approximately 8 o'clock. And the witness himself said he cleared snow at approximately 11 o'clock or a little before. However, he never testified that there was any more accumulation. He was actually asked at his deposition, when you went out at 11 or so to shovel, was there more snow? Was there less snow? Was it the same? He said, I don't know. The most he could say was there was not much, maybe an inch. And even if you consider that testimony, it doesn't line up with our own experts' data, because the data he submitted while being from other counties doesn't show that it snowed at all after about 6:35 p.m. in these other counties. So I don't see how defendants conclusively showed that there was a storm in progress, which was the language used by this court in that Augusto decision from earlier this year.
Mm-hmm.
I could speak to our alternative argument on creation, but I think the main issues here are what I already discussed. If you have any other questions, I'd be happy to answer them.
All right, well then, we'll give you the time on rebuttal if there's anything else, okay?
Thank you.
Very much, Mr. Friedman.
Good afternoon, Lisa Gokulsing for the respondents. In the plaintiff's opening brief, they argued, don't look at the meteorological evidence. We know that the case law says that under 4518 that the meteorological evidence is usually enough to establish what the weather conditions were. But don't look at that because they used official weather records, but not from the Bronx.
The Bronx does have different weather conditions than LaGuardia Airport or Central Park. There are different conditions sometimes.
They are, but generally speaking, this particular evening, the weather conditions were consistent across the different weather stations. I'm sorry?
How do you know that that particular evening they were consistent?
Oh, just based on the weather records that are in the record. That evening, the weather records were pretty consistent over the different weather stations that.
But none of those weather stations were in the Bronx.
That's right. There is not an official weather station in the Bronx.
Right. The Bronx is on the mainland. It's the only borough that's on the mainland.
That's right.
And has colder, generally speaking, colder, more severe weather conditions than Central Park or LaGuardia.
That's right. But, so in the respondent's brief, responding to that argument that we shouldn't rely on the meteorologist's records, we looked to the witness testimony. And the plaintiff testified that when he arrived at the deli, yes, in fact, the sidewalk was covered with snow. And then we also looked at the testimony of his cousin, Luis Eduardo, who testified that Tururo cleaned the sidewalk somewhere between 8 and 9 p.m. That's at 2:56 in the record. And then he went out at 11 p.m., and at 11 p.m., he cleared about 1 inch of snow. He cleared a single path. He didn't clear the entire sidewalk. He was very clear about that. And then viewing the evidence in a light most favorable to the plaintiff, we have to rely on his own testimony as to what caused his accident. He doesn't know exactly where he fell, but what he was clear on was that what he fell on was unshoveled snow. That is the best evidence in this case because my client didn't see the accident, didn't witness the accident, and couldn't say for sure where the plaintiff fell. So the plaintiff's own testimony, his own judicial admission regarding the condition that caused his fall is the best evidence in this case. So you combine the meteorological evidence, you combine the fact testimony regarding the weather conditions that evening in that specific area, that specific block in the Bronx, and what you have is a storm in progress. On that basis, the duty of both defendants in this case were suspended due to either the storm in progress doctrine or under Administrative Code 16123. If there are no questions, I will rest on my brief.
Okay,
Thank you.
thank you very much.
I hope to be even more brief now than before. Just to touch back on this data from other counties issues, defendant glossed over completely in their brief, and now they're essentially saying, well, yes, we have no evidence from the Bronx, but it doesn't matter because the parties testified that there was snow on the ground. The issue is not whether there was snow on the ground. The issue, of course, is when the storm ended, or as this court held in...
I mean, if there are no sites in the Bronx where you can get these official records from, I mean, what could you have done in some way to have opposed the testimony that was presented by defendant's counsel who gave you weather stations from Queens, Manhattan, Teterboro? I mean, I know they were Westchester. No, they were all around the Bronx. They weren't the Bronx, but if yours was something different, if you had some different testimony, wasn't it beholden upon you to present that to the court?
Respectfully, it was, and I'm going to point to the decisions we have in our brief, Simpson, LeBron, Ralat. Those are out of this court, and then there are a few from the second department that say straight out the defendant does not meet its initial burden when this is the kind of evidence they submit. It's an interesting question, and it may have been one thing had their experts said no data was available for the Bronx, but there was absolutely zero explanation given, and some of these cases have specifically involved situations just like here, where there's an accident in the Bronx, and the only weather records there were from other counties. So I don't know what the reason for not including records from the Bronx was. It's simply not in the record. But again, as this court said in Powell and in the more recent decisions, Tracy, Vosper, I'll probably butcher this one, but Nadaye, they're all in our brief. If the storm has trailed off to such an extent that there's no real appreciable accumulation, you have no storm in progress defense as a matter of law.
Okay, thank you both very much. We'll take another look.
Thank you, Your Honors.
The next case for argument is Kevin W. Okay, good afternoon. You may begin.
Good afternoon, and may it please the court, David Chalik-Klein, Bronx Defenders, for appellant father, Mr. W. In the trial court, all parties stipulated that Mr. W was his son's caregiver. At the end of the evidentiary hearing, the judge ordered Mr. W to stay away from his son, except for visits twice a week for 2 hours. This was a removal of Mr. W's son from his care.
And didn't the court sort of admit that at the outset by describing the hearing that would unfold as a 1027 hearing?
Correct. The court specifically said this is a 1027 hearing. And because it was a 1027 hearing, the statute mandates that in order for a removal to be effectuated, the court needs to make a finding of imminent risk. But the court did not make such a finding, and ACS did not make such a showing. And ACS doesn't even argue in this court that it made that showing, effectively conceding that the child was not at risk of imminent harm. Instead, ACS now says, for the first time on appeal, that it doesn't have to prove imminent harm. In its view, the government can remove a child from a parent based on allegations alone. This notion is antithetical to constitutional principles, is contrary to this court's opinions that have repeatedly safeguarded the due process rights of parents, and violates the plain language and purpose of Section 1027 of the Family Court Act. When the government wants to take a child away from their parent, one of the greatest deprivations imaginable, it must prove that the removal is necessary. Not only did ACS fail to do so here, but it rejects any responsibility to do so. There is no basis for the order of protection in this case, and this court should vacate it. I want to turn first, Your Honors, to the stipulation that I mentioned. In the trial court, where of course facts are developed, ACS agreed, stipulated, that Mr. W was his child's caretaker. After this stipulation, Mr. W did not have the opportunity or indeed the motivation to further develop the extent and degree of his relationship with his son. This is precisely why it is a basic tenet of appellate law that parties can't take contrary positions on appeal than they took in the trial court. This is decisive in this case. ACS cannot now walk back its stipulation and argue that there is not an adequate factual basis to establish Mr. W as the caretaker of his son. And because it is undisputed that Mr. W was his child's caretaker, Judge Moulton, as Your Honor asked, the family court was required to hold a 1027 hearing and make a finding of Elizabeth C. It is the exact same thing, we are asking this court to say the exact same thing that the Second Department said in Elizabeth C. It is straightforward and it is simple. And importantly, ACS does not argue here that the reasoning of Elizabeth C. Was incorrect. Instead, ACS now constructs an argument based on meaningless factual distinctions that are irrelevant, and they are irrelevant precisely because there was a stipulation that Mr. W was his father's caretaker. And to further see exactly why a 1027 hearing was so important, it's important to compare the father's access to his child before the order and after the order, and why that resulted in a massive disruption in Mr. W's care of his son. Before the court issued the order of protection, Mr. W had unfettered access to his child. After the order, he could not see his child, talk to his child, take him to doctor's appointments, do anything that he was usually able to do at his father. And because there was this massive disruption, the legislature has stated, and due process requires, that there had to be a hearing where imminent risk was shown.
Thank you. You'll have 2 minutes for rebuttal.
Thank you.
I don't know which of the respondents wants to go first. Okay, you'll just tell us who you are then?
Yes, Your Honor.
Okay, you may begin.
Yes, Your Honor. Good afternoon, Your Honors. My name is Cynthia Cow, appearing on behalf of the Administration for Children's Services.
Thank you.
Your Honor, the family court never held a 1027 hearing in this case, and this court need not look any further than the order that's being appealed from, and that's a 1029 or a temporary order of protection. It's clear from the outset that the family court did not believe that the father was entitled to a 1027 hearing.
At some point during the hearing, which I believe is November 20th, 2020, didn't the court, in addressing Mr. Shalek Klein, say, this is a 1027 hearing?
Your Honor, that
Was
is,
that just a mistake, or what was that?
I submit that was a mistake, Your Honor. I believe that the court misspoke. That was one instance out of maybe a dozen instances where the family court made it very clear. And I would point, Your Honor, to ACS's brief on page 5. On every single court date, the court was very explicit that this is only a hearing as to ACS's application for a temporary order of protection. And
But
even
counsel,
on one point,
counsel, since it did concern severance of contact between the child and the father, didn't it have to be a 1027 hearing?
Your Honor, in this particular case, under these circumstances, there was no evidence that the father and the child lived together, number one. The mother and the child lived in a separate residence, has always maintained a separate residence, and in fact, she left after the allegations, the incidents of domestic violence occurred.
Didn't you stipulate at one time that the father was a caretaker to the child?
Yes, but even so, Your Honor, being a caretaker is a separate issue apart from having custodial status here. A caretaker can be a PLR. If a court, can just simply grant a 1027 to any PLR.
What's a PLR?
Oh, I'm sorry, a person legally responsible for the child having no relationship to the child, they're circumventing the whole custody procedures. In this particular
There was
case,
no custody order in this case, however, correct?
that is correct, Your Honor. There was no custody order. Contrary to what the father's attorney says now, he did not have unfettered access. His access was whatever the mother had decided. He even testified below that they had argued about visitation because he didn't have unfettered access to this child. So this was not a 1027 hearing, plain and simple. This was a 1029 hearing. This temporary order of protection expired 3 months ago, long expired. It is now moot. This court must dismiss the appeal based on the mootness. There's no exception to the mootness rule. There's no enduring
What
legal
about the fact that there's a order of protection that supersedes that February order?
That's correct. Your Honor, absolutely, the father's attorney did file a notice of appeal from the subsequent order of protection. However, he didn't perfect that appeal, and there was information outside of this record before this court regarding some court conference that occurred on February 3rd, 2021, when the subsequent temporary order of protection was issued. And I submit that this record is confined up to what occurred on December 23rd, 2020. It's improper for the father to now throw in the information outside the record. I ask that the court dismiss the appeal or, in the alternative, affirm that there was good cause to issue the temporary order of protection. Thank you.
Okay. Thank you very much. We'll now hear from the attorney for the child. Is that Ms. Singh?
Yes.
Okay.
May it please the court, Reethi Singh, appearing on behalf of the child. So I will adopt the presentment agency's argument, and I'd like to emphasize a couple of things. So this was not a removal. My client lived with his mother and, yes, had frequent contact with his father. However, he lived with his mother. This was a hearing on an order of protection, as the court repeatedly emphasized, even on the last day of the hearing. I believe it was December 23rd. The court specified, this is a hearing on an order of protection. It's not a release to the father. It's not something that the Second Department contemplated when it decided Elizabeth C. And as such, since this wasn't a removal, this was not a 1027, 1028 hearing, despite counsel for appellant's repeated insistence that it was. So yes, your honors are correct in that the court, I believe on 2 occasions, referred to the hearing as a 1027, but more often than that, and importantly on the very last day of the hearing, recognized that it was a hearing on the order of protection, which is squarely covered by 1029 of the Family Court Act.
If I may, am I correct that neither you nor ACS have ever argued that the father posed an imminent risk to the child?
No, I believe that the facts adduced at the hearing did constitute imminent risk to the child, as there was an incident of domestic violence during which the mother was stabbed in the leg and the child was present at home and he was 2 years old. However, imminent risk is not the standard that the court was using in this hearing because it was
Well,
not.
if it's a 1027, that would be what they would use, correct?
Under a 1027 hearing, that is the standard, correct. But here, instead of expanding the reaches of 1027, 1028, the court doesn't even need to do that. 1029 exists for orders of protection like this, in which a parent doesn't cohabitate with the child, prior to the petition. I'd also like to emphasize something. Appellant often indicates that this order of protection severely restricted or completely eliminated the contact that the father could have with with my client. In fact, the language of the order that the court issued was about as expansive as possible. It allows for agency-arranged visits. It doesn't specify supervised, it doesn't specify agency supervised, it doesn't specify overnights. In fact, it allowed ACS to expand visits accordingly without having to come back to court for additional intervention. So it was about as expansive an order as the court could issue, given the facts of this case. So unless your honors have any additional questions, I respectfully rest on my brief and ask you to affirm the family court's order.
Okay, thank
Thank
you very
you.
much, Ms. Singh. Mr. Shalak-Klein?
Also, can you pick up that thread about the fact that there was visitation provided in the TOP? And also, it's a temporary order of protection, right? So it does eventually expire. So given those two things, was there a severance of contact?
Absolutely, and I want to point the court to the comparison, which was before the government intervention, the father did have unfettered access to his child, and the state had no role to play in restricting that. After the order of protection, the only time, and this is in the court's oral decision, the only time Mr. W. could see his child was twice per week for 2 hours. That is what the court ordered in its oral decision. So the comparison from before to when he had unfettered access to after, when he could see his child only twice a week for 2 hours, couldn't call him, couldn't take him to doctor's appointments, couldn't do anything else that he was doing as a father, is a substantial yes, Judge?
What you just said is not completely consistent with what the attorney for the child said. She said that the court ordered whatever visitation ACS would impose.
So the attorney for the child is incorrect on that factual point. The judge specifically said in his order that two visits per week for 2 hours, and yes, the ACS has discretion potentially in the future to expand that, but that's not Mr. W's decision when he's able to do that. And the Second Department in Elizabeth C., in fact, talked about this, and the factual situation in Elizabeth C. was that the parent in that case only had a certain number of visits per week, and the court said that because that was a substantial severance, that triggered the right to a 1027 hearing. And I want to pick up on a point that my adversary stated that this was not a 1027 hearing, and maybe it was a mistake that the family court judge said that it was a 1027 hearing. Context is specific. On the very first day of the hearing, the judge inquired, I'm not sure if this is a 1027 hearing. Then there was argument from counsel about why this was a removal pursuant to a case law in Elizabeth C. The very next day, we came back and the judge said, that's in the second day of the transcript, this is a 1027 hearing. No party objected to it. No party said, no, it's not. And in fact, there were then additional references to it as a 1027 hearing. And counsel continued to reference it as a 1027 hearing. And nobody said, no, this is a 1029 or this is good cause. 1029 and good cause, you will not find those phrases in the transcripts in the trial court. They do not exist. And if I could just make one further point, Your Honor.
Go ahead.
My adversaries try to draw a bright line distinction between whether there's a 1027 hearing or an order of protection hearing. But of course, orders of protection are the issue at 1027 hearings all the time. The relief that ACS is asking for is a full order of protection, and that's what triggers the right to a 1027 hearing, and that because that's the relief sought, there is no difference in these circumstances between a 1027 hearing and a temporary order of protection hearing. Thank you, Your Honors, very much.
Okay, thank you.
Unless there are any more questions.
No, I think we're not shy, so thank you very much, counselors, all of you, for coming in. We appreciate that. The next case for argument is Schmidt-Sarosi versus Offices for Fertility and Reproductive Medicine. Funny. Okay. Good afternoon. You are Miss Lundy?
Yes, good afternoon, Your Honors. And may it please the Court. Catherine Lundy of Freeborn and Peters on behalf of Appellant Plaintiff Dr. Cecilia Schmidt-Sarosi. Your Honors, Appellant is here to address two issues concerning the lower court's order pursuant to CPLR 3211A1 and 7, dismissing her New York labor law claims. First, whether the lower court erred in dismissing the unlawful deduction claims under Section 193 on the basis that, and I quote, this is a contract case. And second, dismissing the retaliation claim under Section 215 on the basis that it is contingent upon an actual violation of the New York labor law. With respect to the first issues of unlawful deductions, the lower court's order, finding that this is a contract case and simply an issue of miscalculation, fails to address two critical points.
Well, doesn't labor law, or the section, the statute, labor law 193 specifically say that no employer shall make any deductions unless they're expressly authorized, ... So how is that not included, even if there is a breach of contract?
That wasn't addressed. It's appellant's position that these were impermissible deductions, both by law and by agreement. By law, that's delineated within the statute, and by agreement, the agreement specifically identifies what may be deducted. This is not a limited agreement. There are 3 sections that identify what can be deducted, and nowhere in any of those provisions does it identify that operating costs or even electric bills can be deducted from Dr. Schmidt-Sarosi's earned compensation.
What can be deducted from her compensation?
Medical malpractice insurance, personal professional expenses, automobiles, and several others that are expressly identified in Section 7B, D, and E of the agreement. But nowhere does it identify electric bills or operating costs. The court doesn't address that, however. In the order, it simply determines that it was a breach of contract. But to conclude that an exempt professional can only proceed under a breach of contract claim negates the ability for an exempt professional to also utilize Section 193 when there was an impermissible deduction on her earned compensation. Not only does the court not address whether or not this was a permissible deduction, the court also doesn't address whether or not these deductions were made either before or after they were earned. Appellant maintains that the complaint specifically identifies that these deductions were made after they were earned. And unlike Pachter, here we have an agreement that identifies when compensation is earned. It's earned 30 days after the end of each quarter. The complaint specifically identifies that and specifically identifies that the deductions were made after that point. In opposition, the respondents rely on the holding in Perella-Weinberg, which maintains that a wholesale withholding of wages doesn't constitute a Section 193 violation. But that case is distinguishable from those here. Here, Dr. Smith-Shirosi was paid a portion of her compensation. She was paid a portion of her compensation throughout the duration of her employment, and from those wages, the deductions were taken. Respondents should not be permitted to avoid liability simply by claiming that this is a miscalculation, and these issues can be addressed on the breach of contract claim. To do so would allow every employer to avoid liability under the New York labor law, and that's simply not the intent of the law. Turning next to the retaliation claim under Section 2.
Excuse me, you're asking us to reinstate this complaint as to both respondents, the individual Dr. Rajabi and the OFRM, the Office of Fertility and Reproductive Medicine? Is that correct?
Yes, Your Honor. Under the definition under the New York labor law, both Dr. Rajabi and the practice itself constitutes employers. Turning next to the claim for retaliation under Section 215, the statute was amended effective April 9, 2011, thereby no longer requiring an actual violation of the New York labor law, only that the employee has a reasonable and good faith belief that a violation had occurred. Nevertheless, a lower court determined that because the cause of action for unlawful deductions were dismissed, so too must a retaliation claim be dismissed. That is inconsistent with the express terms of the statute. And what's significant here today, so far we have very limited case law addressing this amendment to the statute. However, what we do have is Section 741 of the whistleblower statute with identical terms and consistently determined to mean that when an employee has a reasonable and good faith belief that the standard has been violated, that would be protected activity. Conversely, under Section 740, there would have to be an actual violation. That language in 740 and 741 is consistent or similar to what we're addressing today, which is the prior amendment of Section 215 and what currently exists today. The complaint alleges that Dr. Smith-Shirosi had a reasonable belief that a violation occurred. She raised it to her employer, and less than 4 weeks later, she was terminated.
Excuse me, I'm sorry to interrupt your train of thought, but are there any portions of the complaint that the court did not dismiss against OFRM? Any claims at all?
Yes, Your Honors.
Because I see the court dismissed the entire complaint as to the individual doctor, right?
Correct. The only complaint, the only causes of action against the individual doctor, Dr. Rajabi, was the New York labor law claims. The 2 labor law claims were dismissed, but the remaining portions of the complaint that only related to the practice group, the breach of contract, the breach of good faith and fair dealing, and the declaratory judgment causes of action all remain.
Thank you.
Thank you.
Good afternoon, Your Honors. Richard Brosnick from Ackerman LLP for both respondents. I think the most important point to address here is that we don't slip rhetorically between earned wages and net fees. The lower court correctly found this to be just a breach of contract claim because although opposing counsel's papers concede that the alleged deductions are from net fees, there are no deductions from earned wages. There simply aren't. If Your Honors look at Section 7 of the underlying contract, which I should note is not outside evidence, it was attached to the complaint, and so it is part of the appellant's pleading. Section 7B clearly says, 7A, clearly says that net fees are determined based on a calculation of all of the appellant's collections based on the appellant's services. Then, from that basis, there is a further contractual calculation from which earned wages are determined.
And what is that? What is it that you're allowed to deduct from the fees that are earned?
Right. The contract does not address what can be deducted from net fees. It only addresses, and this is Section 7B on, I believe, page Your Honor.
51 of the record.
Yeah. Section 7B defines net fees as actual collections based on the appellant's services and some other factors. So the question becomes one of contractual interpretation of, are the matters that appellant is talking about actual collections? Clearly, in the breach of contract claim below, in the trial court, respondents will be arguing that credit card fees, bank fees, insurance company fees that are deducted and never collected by OFRM are never net. They're not deducted from net fees. That's a rhetorical term of art. They are simply not net fees by definition. But I don't want to devolve into that discussion, because that is a contractual interpretation question, and exactly what this court said is not a Section 193 issue in the Perella decision. What we're talking about here is that if there's one point to get across, it's that net fees are not earned wages, are not. Now, my opposing counsel tries to say, well, net fees become earned wages after 30 days. No, they do not. And I would again urge Your Honors to look at Section 7A of the contract, which is part of the pleading. The net fees are determined at a certain basis based on the definition in 7B, and then a contractual calculation takes place. Net fees don't become compensation. They become a basis from which compensation wages are calculated.
You're using a lot of different terms. Under Labor Law 193, it specifically says that no employer shall make any deduction from the wages of an employee except deductions which are expressly authorized in writing. So you're saying these are not wages?
Exactly, Your Honor.
And why are you saying these are not
Because,
wages?
and I'm looking at Section 7, A and B, they have to be read together. The allegation is that the purported deductions, actually the elements that don't qualify as, are from net fees. Net fees is a defined term in the contract. It is not. Opposing counsel uses it, attempts to use it synonymously with wages.
Yeah,
but it is
but
not.
I'm saying wages is not a defined term in the.
No, compensation is a defined term. And compensation, this is Section 7A, is a calculation based on net fees, not net fees itself.
Okay, but so there's the term compensation, there's the term net fees, and then there's another term that's used in the labor law statute, wages.
Right.
So
Your Honor, we would argue that clearly net fees, capital N, capital F, is not wages, because there is no argument that appellant was allowed to just take all of the net fees. Net fees was a basis to which percentages would be applied, and then appellant would be entitled to compensation, wages, of some percentage of that. Now, Your Honor, this is exactly what the Third Department addressed in the Kletter v. Fleming case, which I'll note is prominently in our opposition brief and not addressed at all, either on moving appellant or on reply. I'll just read it. It's exactly, it merely amplified his breach of contract claim. It was another medical professional. This dispute as to the calculation of the net amount does not reflect the deduction of wages. That is exactly this case. Now, granted, that's a Third Department decision, but it is on all fours here.
Counselor, are you also representing the doctor individually?
Yes, Your Honor, I represent both defendants. The labor law claims are the only claims against Dr. Rajabi. So with the labor law claims dismissal, Dr. Rajabi was dismissed as a defendant. Your Honor, unless there are further questions, in my remaining time, I wanted to at least address the tremendous expansion of Section 215 retaliation that appellant is asking this court to endorse. Once again, she is attempting to rhetorically slip back and forth between a violation and an allegation. No one is claiming, we are not saying that a violation must be proved. Clearly, the amendment in 2010 was clear that there is no requirement to prove a violation of the labor law in order to allege retaliation. But you must be able to at least state a claim for an underlying labor law violation. Although appellant's reply brief says, and I'm quoting, appellant complained of conduct that could reasonably be construed as violations of the labor law, end quote, that's not true. she could not plead a claim. She could not state, she could not allege facts that, if true, would have stated a labor law claim. So appellant is asking this court to adopt a standard that that reasonable good faith belief simply means I said it. That if she says it was a violation, then ipso facto you can have a retaliation claim.
Well, isn't she alleging that she was terminated after complaining about unlawful deductions from her wages?
She is alleging that she wrote a letter making that statement, i.e. she said it, and then she was terminated because, and this is outside the scope of the appeal, but she was also starting a competing practice and violating her contract.
Didn't the termination occur a mere 4 weeks after the letter complaining about what she said were unlawful deductions?
The termination did occur some number, I forget the exact number of weeks, but some number of weeks later. But, Your Honor, the legally dispositive point is that appellant was not able to state a claim. Unlike, she tries to analogize to Section 740 and 741, the cases cited on those statutes are consistent. They require a claim, conduct to be alleged that, if true, would constitute a violation of those labor law sections. Here, the lower court correctly determined that because there are no deductions, because we're talking about a contractual interpretation of what are net fees, not any deduction from earned wages, there can be no Section 193 claim, and because there can be no underlying predicate claim, not because there was no violation, but because there was not even any allegation, any pleading of an underlying claim, there cannot be any retaliation claim.
Okay, Counselor, we've given you several extra minutes. Thank you very much.
Thank you.
Briefly, Your Honors, respondents focus on the term net fees. Net fees is a defined term in the agreement.
Right.
However, the complaint specifically is addressing the term compensation, which is also defined. Compensation consists of an unrecoverable draw and a net bonus payment. It is appellant's position, as alleged in the complaint, that her compensation was paid in part by the unrecoverable draw and unlawful deductions was taken from her earned wages. To the extent we are addressing net fees, which is an underlying component to that term compensation, net fees also has a very specific definition, like the deductions permissible under the agreement. It provides, in relevant part, actual cash collections less any fees returned by patients. It doesn't say less operating costs, less electric bills. Nowhere in that unambiguous provision does it state that those expenses can be deducted from net fees. At the very least, there is a question as to who is right in the interpretation of this agreement. This is not ripe for dismissal at this stage of litigation.
What about the term wages that's used in the labor law? How is that differentiated from the term compensation as defined in the agreement, and net fees that's defined in the agreement, but the term wages does not, is not specifically defined. So I'm trying to figure out how these three terms interact with each other.
Yes, Your Honor. Wages, in this instance, is interchangeable with the term compensation. And compensation is the amount of funds that Dr. Schmidt-Sarosi earned during her employment.
Could you address Mr. Brosnick's comment that you never dealt with that Kletter case, and how would you distinguish it, if you can distinguish it from the facts in this case?
In this case, what the complaint alleges is different from those that the respondent is relying on in the Kletter case. In particular, here, the wages are defined in the agreement and they were earned, and following the wages being earned, deductions were taken. The facts are distinguishable, and they're distinguishable because of the express terms of the agreement. And if I can briefly address the retaliation component.
You have just like 30 seconds. Go ahead.
Yes. The fact that the Section 193 claim, even if that was remained dismissed. It doesn't mean that the retaliation claim under Section 215 must be dismissed as well. And I respectfully refer your honors to the Orem v. SoulCycle case, in which the underlying New York labor law cause of action was dismissed, but the retaliation claim was sustained because there was a reasonable belief. Thank you, your honors.
Okay. Thank you both very much. All right, the next case for argument is Tershwell versus TCW. Okay, good afternoon. You may begin.
Good afternoon, Your Honors. May it please the Court, Stephen Storch for the plaintiff appellant, cross Appellate, Sarah Tershwell. Your Honors, one thing that permeates every aspect of the appeal here is that the trial court below engaged in fact determination as opposed to identification. And in each case, the court weighed the evidence, decided which evidence it was going to look at, excluded certain plaintiff's evidence, and then decided an issue that was distinctly for the jury. And there are two examples that I'd like to call out. One, the first one, is on punitive damages. The court found there's a disputed issue of fact as to whether the defendant Ravitch had actually assaulted Ms. Tershwell, and said that needed to go to the jury. He then found, though, that no jury could determine that Ms. Tershwell was entitled to punitive damages on that claim. That there was no way that, even if the jury believed that that took place, that they could find that that was wanton negligence or willful indifference. And we submit that's just one example of where the court took over the province of the jury. On the retaliation claim, the judge made the determination that no jury could conclude that Ms. Tershwell was terminated for cause 9 days after she filed the complaint for sexual harassment. His principal basis for that was his determination that her termination for disclosing a publicly available article was the real basis why TCW terminated her, and that there was no dispute that she had been told some months earlier that if she did anything like that, she would be fired. And he even went in to say that Ms. Tershwell didn't even dispute that, and TCW and the Ravitch defendants contend that she didn't.
Now, Mr. Storch, there were in the record very clearly several violations that had occurred during her relatively short compliance violations that occurred during the time of her employment, and it wasn't clear enough from the record that that was the reason that they said, look, anything else happens, that's the end, because of, all these different violations?
Your Honor, one thing, what they took, their position on the termination was that she turned over this public article. It was the supposed fifth violation, and that was it. The problem is, they said, well, we told her if she did this again, she'd be fired. Except the evidence was that there was no written warning to her, as her contract would require. There was no writing of any kind other than their say-so. Ms. Tershwell testified that she didn't remember such a warning. Their own internal rules at TCW didn't forbid the turning over of public information. In fact, Meredith Jackson, the general counsel of TCW, the person who fired Tershwell, actually sent Tershwell an email some months earlier encouraging her to do exactly what they fired her for. They don't dispute that. So with respect to that fifth violation, our position is there was no violation because there was no policy that she couldn't hand a public article. And in fact, we put in expert testimony that said there'd be no reason for that. Why in the world would anybody be precluded from disclosing what's publicly available? Your Honor, with respect to the other alleged violations, our position is that with respect to one violation, it wasn't even a violation. They themselves had recognized it wasn't a violation. Sometime in around August or so of the year when they terminated.
Counsel, do you need the expert's affidavit to help prove that up concerning the de minimis aspect of the compliance violations? Because those affidavits were excluded, correct?
The affidavits were excluded. Your Honor, the answer is no. We believe that based on the facts, that we don't need the expert for that, but the expert does buttress the notion that why would anybody in the world have a rule for this? And our position is that there was no such rule. They made up this rule because they were looking for a reason to get rid of her 9 days after she filed the complaint. On the other violation I was just speaking about, they actually, when the alleged violation took place, they acknowledged, TCW acknowledged, that it was at least in part, if not largely, their own fault because their computer system wasn't working. They wrote a note in her file saying, we've promised Ms. Tershwell if this ever comes up, we will point that out to the board. When they went to the board and decided to suddenly claim that it was a violation, they omitted the reference to the fact that it was their fault. They actually consciously excluded it. We have it in the record that they say, here, use this copy, which excluded that. Also, we have in the record at the same time a male committed the same alleged violation. He wasn't sanctioned. He was, quote, spoken to. And unlike Ms. Tershwell, who was forced to disgorge the small profit that she made in connection with the transaction, he was not. So that's further evidence of the disparate treatment with respect to violations. With respect, if I may move on to an issue,
Go ahead.
Mr. Ravitch, with respect to his position that he can't be responsible for retaliation for the termination. Mr. Ravitch says, well, there's no evidence that I made the final decision to fire her. And in fact, at the trial court below, I conceded that we don't have evidence that the final decision to terminate her was made by Mr. Ravitch. But as we point out in the Morello case, which we cite, there's no need that Mr. Ravitch had been involved in that final decision because the evidence showed he had set in motion various things that led ultimately to her termination. He had helped round up people to come in and complain about Ms. Tershwell after she stopped having the unwelcome sexual relations with her. He had set up a separate team of men to take over from her starting in the summer, shortly after she had stopped having the sexual relations with her. He had cut off marketing so that, in fact, they could not go out and gain additional investors. He put in place all the things that led to the termination, including just a few weeks before the termination. There is evidence in this record that Mr. Ravitch helped draft the email that talked about terminating Ms. Tershwell about a fifth violation, which hadn't even occurred yet. They were looking for a fifth violation, and they were already drafting the letter. Mr. Ravitch says, there's nothing in the record to support that. There absolutely is. There's the general counsel who testified, oh yeah, we were drafting this, and I circulated it, and Mr. Ravitch was involved.
Okay, Mr. Storch, you'll have a few minutes on rebuttal. Let's hear from the respondents. Thank you. And I guess you decided who should go first. So who are you and who do you represent?
Thank you, Your Honor. Robert Sachs from Sullivan and Cromwell, representing the individual Jess Ravitch.
Okay.
Let me start with the retaliation issue. Mr. Storch has left out some important things. The court below correctly dismissed the retaliation claim because the plaintiff did not offer evidence to establish a prima facie case. An essential element or elements of a retaliation claim are evidence of adverse action by the defendant causally related to the protected activity. Mr. Storch below admitted the protected activity is a complaint that was filed on December 5th, 2017. That's the only protected activity on which this claim is based. He also admitted below in open court that Defendant Ravitch not only took no action as part of the termination, but he had no involvement whatsoever with respect to anything having to do with Ms. Tershwell after December 5th of 2017. Under the standard set forth by this court in Cadet Legros, I'm sorry if I pronounced the French incorrectly, that's the end of this claim. Now, he may have a discrimination claim under the New York City human rights law under different theories with all the facts he's just spun, which, by the way, Your Honor, are not in the record, but I commend you to the record. But he doesn't have a retaliatory termination claim against Mr. Ravitch. If there is a claim, if there is a dispute as to whether this was pretext or whether it was made up, none of that has to do with Mr. Ravitch whatsoever.
Well, the claim against your client under the, can you hear me? The claim, the gender discrimination claim against your client under the city human rights law was sustained by the court.
Correct, Your Honor.
And if we were to agree, I mean, you're cross-appealing on that issue, as I understand it. But if we were to agree that the court was correct in sustaining that claim, why would it not be proper to reinstate the punitive damages claim?
Your Honor, for several reasons on punitive damages. First of all, the court you have to look at the record as a whole and the evidence that the plaintiff adduced. Plaintiff's view is basically that if Mr. Ravitch, there is a dispute obviously in the record, but if Mr. Ravitch and Ms. Tershwell, who were former boyfriend and girlfriend, had sex 3 times more than 15 months before her termination, necessarily that gives rise to a claim for punitive damages. That's not, I believe, Your Honor, consistent with Shaka. You have to look at the record that she adduced. She previously had a long-term relation. There's a dispute as to that, and you look at what she did or did not say about those 3 incidents, Your Honor. She didn't say anything that would give rise to anything that might suggest gross misbehavior. She testified as to a long-term romantic relationship. The undisputed record is that Mr. Ravitch supported continuing her employment at all times, extending her contract, awarding her stock options.
No, but then there are allegations, of course, in the complaint that I'm sure you're about to address, that he retaliated against her when she ceased having sex with him.
Your Honor, the record on that is, again, something I suggest that the court look at because...
Well, it's really not for me to look at, it's for the jury to look at.
No, Your Honor, I'd say no, and the reason we say no on that is the following, is not putting aside the allegations, look at the evidence that she adduced, that she came forward with on the record on summary judgment. She testified, Your Honor, that she never told Mr. Ravitch she was not having sex with him. Never. Her testimony on that subject was it just no longer happened.
Well, he probably noticed that she stopped showing up for the breakfast meeting.
No, Your Honor, she testified he never asked to have a breakfast meeting after this happened as well. So, Your Honor, that's why I say look at the record, not the allegations in this case. Here, Your Honor, I can read you that. And you're saying you allege that you stopped the alleged sex. What did you do to stop it? I stopped going. Did you speak to Jess and say anything to him? No. So you just didn't show up? I don't understand. Just didn't do it anymore. Was there no incident or event about you said anything to Jess about it? Right. Just didn't happen anymore. Right. Did he ever raise the subject after that? I don't recall. Did Jess ever ask you, after you stopped these meetings, to have a breakfast meeting with him? I don't remember. Your Honor, the record on this subject is replete with no connection between the allegations of discrimination, which started, according to her, in March of 2017, and the cessation of sex, which, based on the record here, stopped in September of 2016. And in between those 2 periods of time, Mr. Ravitch invested personally $5 million in the fund to allow it to launch, obtained a $20 million investor for $40 million, for 40% of the fund.
Weren't there also claims by the plaintiff in the record that after she stopped having a sexual relationship with your client, that things changed in terms of the support for her distress fund and other things like that, which created a problem for her.
Again, Your Honor, that's what I'm addressing at the moment. She says it, but the evidence that she adduced shows that the last date on which there is the slightest evidence that the two of them were together and could have had sex together was the beginning of September of 2016. She alleges wrongful conduct beginning in March of 2017, 5 months. During that intervening period of 5 months, which is when the sex supposedly stopped and she would have done whatever she didn't do at that point to him, he invested $5 million. He got a $20 million investor to allow it to begin. He got her contract extended for a year, the auto termination date. Your Honor, contemporaneously with the time she says he was discriminating against her and treating her wrongly, she acknowledges that that Mr. Ravitch got Mr. Lippman to extend her contract for a year. It doesn't make any sense. There's a 5-month period of time here that's unexplained by the evidence in the record as opposed to just the vague allegations of the complaint, Your Honor. Thank you.
Okay, thank you very much, Mr. Sachs. Can you,
If it please the court, Jonathan Solds from Greenberg Traurig on behalf of the TCW defendants. The court below got it exactly right with respect to plaintiff's claims of retaliation and discrimination and aiding and abetting and breach of the covenant of good faith and fair dealing and punitive damages as against TCW. It properly applied this court's precedents under Melman and under Homburg, under Gettinger, and the Court of Appeals ruling in Chauqua. I want to stop right there because what the court did was not invade the province of the jury. What it did was to determine the total absence of admissible evidence on any of those claims that would give rise to a triable issue. It is a fact that the discharge here took place shortly after the filing of a harassment claim. But it is also a fact, and it is undisputed, that there was a violation, a fifth violation, an unprecedented number of violations within a 2-year period by the plaintiff in that time. Trust is the very lifeblood of an organization like TCW. Clients are dependent on the rules being observed in order that their interests are safeguarded. And compliance violations are corrosive of that trust.
Counsel, in that case, was it Mr. Ferber who described the compliance?
Sorry, I can't hear.
Oh, I'm sorry. The exclusion of the affidavit of an expert I'm talking about now, did that harm plaintiff in showing that, in fact, her compliance violations were not that serious?
Well, I want to say 2 or 3 things about that if I can. Number one, you don't have in front of you, and I think this is material to the overall question, an affidavit on personal knowledge from the plaintiff attesting to any of the issues that Mr. Storch tries to bring forward. Number 2, the parties had an understanding and an agreement that's encapsulated and so ordered by the stipulation that said there'll be no experts on summary judgment. Number 3.
No, it doesn't say that, though, counsel.
I beg pardon?
It does not say that. I'm reading it.
I
mean, it's in handwriting. It's not the best handwriting in the world, but it doesn't say that.
Your Honor, the parties exchanged a number of pieces of correspondence. They were heard in open court.
I see. So there's a, counsel, excuse me, there's a gloss that I need to read into the stipulation, or is the
I don't think so, because the standard of review here is whether there's an abuse of discretion. That's the South Shore Delights case, and there's no argument that the judge below abused his discretion. But beyond that, The question isn't whether in some theoretical way somebody could come up with a different set of rules. The plaintiff in this case contractually agreed to abide by the rules TCW had. And there's no doubt that she failed to do it. I'd ask you to take a look at record page number 203. It's a September 2017 email initiated by the plaintiff. This is 6 weeks before the fresh markets violation, which is the last violation, and 6 weeks after she's been warned, indisputably warned, that another violation is going to lead to her discharge. And the plaintiff initiates a request to TCW Legal, is it okay to talk to Direct Lending, the separate group that was also involved in the fresh market situation? And Legal comes back and says, before you talk to them, underscoring the word before in the middle of page 203 of the records, you have to give us some information. The plaintiff indisputably knew what the rule was. That's not only proof that she was warned in August of 2001, and that's an issue that was never raised below. And by the way, if you can say that I don't recall raises a triable issue of fact, then what you're really saying under 3212 of the CPLR is you don't need personal knowledge to oppose the undisputed affidavits of Meredith Jackson and Jeff Engelsman. What you get to say is, I don't recall, and that just makes an issue disputed. That's not what the law is. We cited the Toe case from the Eighth Circuit for that effect. But you not only have record number 203, that Propel Media request to have a communication with Direct Lending, you also have the undisputed, in black and white, ethical law memorandum with respect to the fresh market. That's at 601 and 814 of the record, which absolutely forbade her from talking to Direct Lending or answering any questions. It is absolutely true that what she testified to the plaintiff was that she went to Direct Lending, not that she just gave an article, but she said to them, here's an interesting opportunity. And she said, it'll be yieldy enough. You guys should do this financing. And then, and this is also undisputed, and there's no affidavit that's in front of you which says it didn't happen. When she was asked in the investigatory interview, asked about, didn't you do this? She said, yeah, and then she was reminded, we told you previously you can't do that. We told you it doesn't matter whether it's private or public. We told you you needed permission. She changed her story. She forfeited her trust. This is a case that's controlled by Melman. If I can take 1 second just to change my focus, because I believe that in our brief we've covered all of this, and I believe that the court below completely covers this as well. The point of departure we have from the decision below is with respect to the breach of contract claim, the fourth cause of action. TCW discharged the plaintiff because of her gross negligence, the repeated violations. And what we say, and I believe it's clear in the brief, but if I can take 1 second with respect to it, is under the Court of Appeals decision in Justinian Capital, where the undisputed facts show that a juror could only reach one conclusion, that summary judgment should properly have been granted on this claim.
But given the timing of the termination after the letter, how can we can't throw out that piece of evidence, that's in the record.
Well, I don't think the timing has anything to do with whether she was grossly negligent or not. She didn't follow the rules. That was her choice. That's got nothing to do with TCW.
I didn't say that, but could it have been a pretextual reason because there was this claim made just 9 or 14 or whatever days?
It's undisputed, Judge, that in November, before any protected activity, TCW had already decided to separate the plaintiff for a whole bunch of reasons. So now you have a situation where TCW is faced with a very serious breach of a rule. It's a repeat, sorry, I just dropped my pen. It's a repeat violation, a change of story by a senior fiduciary showing she couldn't be trusted, a fact that's borne out by the fact that subsequent to the litigation, additional violations are found. Why in the world would TCW act like that unless it was so incredibly important that this could not continue with the plaintiff?
Okay.
So this is a case that's controlled by Melman, it
All
seems
right.
to me.
You each have 2 minutes for rebuttal, so I'll let you finish up then or respond to what you need. Thank you very much. Mr. Storch?
Yes, I feel like I should be making this to a jury, what I'm about to say. With respect to the change of story, Ms. Tershwell testified. She didn't change the story. It's their word, what they say went on there, against what her word is. So that's a jury question. With respect to the timing, about 2 hours after Ms. Tershwell met with Human Resources, David Lippman called a meeting of Sarah Tershwell's team, excluded her from the meeting, and went in and talked to the team about what the future was going to look like for the distress fund. Members of the team who sat in there, one of them who testified, said he'd never seen anything like it, and he was embarrassed. That was 2 hours after she made her complaint. He was also supposed to meet with Ms. Tershwell to discuss, where things were going at TCW, and he testified, once she filed the complaint, I wasn't going to meet with her.
Well, but they did hire the lawyer to do an investigation right, immediately, correct?
They hired the lawyer after they fired her. They actually...
We're talking about Ms. Graminia?
Yeah, she was fired. Her retainer was actually signed the day after they terminated her, and the investigation didn't start until several months later. With respect to the Fresh Market memorandum, the Associate General Counsel testified at deposition that there was no non-public information that was involved. Meredith Jackson, the General Counsel, testified at her deposition that it may have been that she heard that Fresh Market memo was issued in error. That's the memo they then dig out 18 months later to try to use as a justification for terminating her. So there was a factual issue as to whether that memo actually ever was in effect. With respect to Mr. Ravitch, he says there's a delay about the alleged failure to give her support. What my brother doesn't recognize is that in February of 2017, Ms. Tershwell says that Mr. Ravitch came into her office. Her door was open. He walked into her office and he put his hand down her blouse. And he also grabbed her private area. And that she was humiliated and worried that her coworkers were standing right outside the office. And she said at that time she had such a visceral reaction, she knew that was it. I think Mr. Ravitch got the message from that reaction. So the notion that, well, she never said anything to her, that's belied by the record. And then you see immediately after that in March, marketing goes down. In April, a new team is started to form by Mr. Ravitch and Mr. Lippman to replace her. They start having secret meetings. They say, and they tell the team, we don't need Sarah involved in this right now. They take away her trading responsibilities, and they severely limit her ability to function in her job.
Okay.
Thank you.
Thank you very much. Mr. Sachs? Is that correct?
Correct, Your Honor. Thank you very much. Very briefly, Your Honor, none of this, of course, has those disputes that you were just talking about have anything to do with the retaliation claim against Mr. Ravitch. He was not involved. Well, let me address the issue of discrimination, the discrimination claim, which is a different claim. The real question, and I go back to what Mr. Solds was saying, is whether let me just say, the last comments by Mr. Storch, I defy the court to find in the record anything that says in February these groping incidents happened. The record, in fact, says she couldn't even remember when any of that happened. But let me address very specifically the issue of whether a claim can be made, Because Ms. Tershwell is today trying to say something that is inconsistent with what she said at the time. If you look at exhibit at 336 in the record, what you find is, Your Honor, that Ms. Tershwell at the time commended the very procedures that she is now saying are discrimination against her. What she said at the time was was, our team seems to be gelling. The hard work that everyone put in earlier this year in establishing protocols and processes shows in the last 5 or 6 months of results and the camaraderie around here. Noah Kramer started in September as a product specialist and has been working hard to ensure that our fund will pass an institutional ODD process so that we may roll out marketing to institutional class
Counsel,
investors.
you have a strong narrative at trial, but this is a messy case.
Your Honor,
I
on
just
this,
don't see you teasing out one narrative and to privilege it against another narrative, which is
I understand the
plaintiff's
point,
narrative.
Your Honor, but this is Ms. Tershwell's statement contemporaneously. She can't create an issue of fact on summary judgment by contradicting her own contemporaneous statements. This isn't another piece of evidence from someone else. This is what Ms. Tershwell said. And now she says there was discrimination. They retaliated against me because they did these things that at the time she said were good and were commending for the performance of the fund. That does not create, Your Honor, an issue of fact. That's not how you can't create your own issue of fact, just like you can't by saying, I don't remember. But again, none of this has to do with the retaliation claim, Your Honor, which was correctly dismissed. Thank you very much.
Thank you, Mr. Sachs. Mr. Solds?
The argument that plaintiff could disregard the Fresh Market Ethical Law Memorandum is really an argument that she gets to pick and choose which rules she wants to obey. The memorandum existed. It specifically told her, if you don't think it ought to be there, it's your responsibility to ask for it to be withdrawn. The undisputed evidence is that there was never any such request. It's in black and white. It told her not to have the contact. And in addition, as I pointed out, to the Propel Media situation, she knew the rule, she applied the rule. There's no question that there was a violation of the rule. As to the timing, let me please come back to that. The timing was not TCW's. The timing was Ms. Tershwell's. And that's critically important, and it's the reason that Millman controls this case. I'd also like to just point out there was a statement made by counsel with respect to the punitive damages issue. Whatever the conclusion may be with respect to what Mr. Ravitch did, there's no showing of any kind that the Chalka standard has been met with respect to TCW. There's no showing TCW knew anything was going on. There's no showing that TCW was informed, no showing that it acted with conscious disregard of any kind of right that Ms. Tershwell had. To the contrary, TCW had all of the necessary procedures in place. And with respect to the question Your Honor asked about the investigation, TCW determined the very day that the harassment claim was filed that it would hire an investigator. It took steps directly right after the harassment complaint was filed to interview on a preliminary basis Ms. Tershwell. It had the same response with Mr. Ravitch. And the fact is that Ms. Tershwell did not participate in the investigative report, but TCW did the right things here.
Okay.
The discharge was compelled by the facts.
We will take a look. There's a lot of issues to digest. We will certainly take another look at it. Thank you all very much for coming in this afternoon. Thank you, Your Honor. Stay well. The next case for argument will be Grandelli versus City of New York. Okay, good afternoon. You're Mr. Gagas?
Gagas, correct.
Gagas, and you represent Liesel. Okay, you may begin.
Yes. Good afternoon, Your Honors. May it please the Court. William Gagas of Costa, Brady, and Nagler on behalf of the appellant, Liesel Transportation. We submit that this case was wrongfully consolidated with a number of other matters arising out of a terrorist attack, which Your Honors may recall on October 31st, 2017, where a rented pickup truck.
I think we're familiar with it. So doesn't the motion court get a lot of deference in making these determinations as to whether it makes sense to consolidate cases that arise out of the same incident?
Certainly, the court has discretion, as is this court on review. However, what is significant here, which I think the other court, who was also dealing with Home Depot's motion to dismiss, overlooked some of the key differences in these cases, which in fact demonstrate they are divergent factually and legally. And this really is two motor vehicle accidents, one along the bicycle path involving 24 other plaintiffs who were killed and grievously injured, and then a separate motor vehicle accident where the truck exited the bicycle path and collided with my client's school bus.
Right.
The plaintiff in my case is a student on that bus. Her claims pertain to very specialized, specific seatbelt regulations and of the like regarding whether or not she was properly
Counsel,
seatbelted.
what about the fact that you have these cross claims against some of the other named defendants? Doesn't that, sort of lean toward a predomination, if that's a word, of the issues in the case? Because you're also asserting claims against them.
Correct, Your Honor. We do have cross claims in the case. However, I don't think there's any risk of any inconsistencies regarding the evidence in that regard. I mean, the respondents here, Home Depot and the trust, their witnesses, I'm sure, will testify identically, if not.
I mean, the thing is, when we're looking at these types of cases, and I mean, they even have a caption that seems to indicate the consolidation in re October 31st, 2007, terrorist, whatever. There's going to be a lot of overlapping evidence, and I think Judge Rodriguez recognized in his decision if somewhere down the road there is some issue relating to jury confusion or something like that, that the appropriate court can make an appropriate instruction at a future date. They could bifurcate issues, whatever. We don't know what's going to go to trial, what's going to happen. But to have all this duplicated testimony in different cases seems, like something that we try to avoid when we're trying to weigh all these issues. I know you're only in this case. I get that.
Right. And I would suggest the inverse, that not so much the bifurcation and the separate issues for trial can be determined at another date. It's rather that consolidating now is premature and shouldn't have been done, because my client is only in this one case. So, and the solution posed by the respondents is that, well, Liesel, you can opt out of all these depositions and all this discovery, but that puts me on the sidelines for the number of years, and that belies the reason for severance. If I'm so separate and I'm not supposed to go to these 24 depositions or participate in the discovery or the motion practice or what have you until I get to my turn, why then wouldn't Liesel, and I believe this is a substantial right to expeditious litigation, which does inure to a defendant as well, why would we not be in position to proceed with our case? And then when and if that case can't be resolved, then the other litigation will surely still be ongoing, and maybe at that time it's appropriate to say, why don't you come join the party? And in that regard, I think it's significant here that none of the plaintiffs have opposed this appeal. Neither did the City of New York, the Parks Department, or the Department of Transportation. And procedurally, Home Depot is also in a position where they've moved to dismiss. They don't believe they're involved in this case. Their motion, which is the subject of this order as well, was denied without prejudice to renewal and subject to the expedited discovery of that client and a deposition and what have you, so that they can renew their motion. So if they succeed, we'll have had that right to expeditious litigation,
Look, I'm
be it
sure that- look,
extracted.
These are complicated cases with a lot of different people, and you're trying to make the right decisions. Other things may develop as it goes along, but I'm sure your case is not going to move ahead in front of the other cases. And the plaintiff in your case isn't complaining about that either.
Well, I respect that, Your Honor. She has not
She's not putting papers
oppose this appeal, and I do believe the interests of justice and the economy, it lays with severing our case, letting it run its course, and then, if necessary, rejoining the remainder of the litigation. And
Okay, I think we got your point. Thank you very much. Why don't you have a seat? You'll have 2 minutes in rebuttal. Which one of the defendants, the respondents, you're all defendants, which one of the respondents wants to go first?
Good afternoon, Your Honor. Jonathan Schaub for the respondent, Hudson River Park Trust. I think there are 3 important issues to consider in framing this appeal. The first is the modern recognition of a preference for consolidation because it allows for judicial economy, which is an issue that this panel has touched on and addressed, and that's going to be particularly important as the courts begin to open up in the post-pandemic era. Running this case along 2 tracks makes absolutely no sense. The second is there were 18 actions underlying this consolidated matter. The only party to oppose consolidation in this case is Liesel. So all of the other attorneys recognize the benefits and efficiencies to be achieved in this case.
Well, look, you get their position, you get where they're coming from. They're only in one case, and they don't want to be, mixed up. But of course, you and your co-respondent, I think, are both also named in that lawsuit. So I understand where they're coming from, but I don't know if I'll ultimately agree with his position.
And another point that I think the court got it right because we're reviewing this for an abuse of discretion and great deference is accorded to the trial court. And the problem is that there are 18 actions, 14 of them, so basically 75% of these actions were brought by the same plaintiff's firm. The allegations in this case, this wrong matter, are identical against the trust and against Home Depot to the other 13 actions. To break these off now makes absolutely no sense. Liesel is focused on the claims against them, but that's only half the equation. The other half, as I said, are those claims that are asserted against us that are identical, verbatim, basically, to the other 13 claims or other 13 cases. And as to the other 4 actions, they all rely on the same theory here. So it doesn't make sense to break these apart. And then the idea that we should do discovery first before ordering consolidation ignores the benefits to be achieved through consolidation. We can streamline discovery and promote efficiencies through one conference, single sets of document demands, one deposition or deposition avoiding multiple depositions of witnesses, and singular motion practice. And then, as the court noted, there are also cross-claims, and for contribution. The theory underlying contribution is a breach of a duty to the plaintiff. So the trust duties to the plaintiff will be at issue by virtue of these contribution claims. So there is no logical basis for breaking these claims apart. And to the extent there's any concerns about prejudice going forward, as the court correctly recognized, there are procedures for that. There can be a severance of an issue when it comes time for trial. And then there's also the fact that there's the severance, there's jury instructions, and as this court held, this case is very similar to the Velasquez case, which gives a template. And in the matter of the New York City asbestos litigation, the court again recognized the ability of a trial judge to manage cases to avoid spillover prejudice. So unless the panel has any other questions, we rest on our brief and believe that the order should be affirmed.
Thank you very much. Okay. And counsel, you represent Home Depot?
Yes, Your Honor. My name is Nicholas Herzler, and I represent Home Depot in this case. Your Honors, I think Mr. Schaub already covered most of the points. I think the court understands the issues here. I just would make maybe a few points that there's a case called Chiachia that we cited in our brief. It says, quote, "A single common issue suffices for consolidation." Here we have numerous issues that are similar with these cases. There's no, operative facts in the Zhang case that would separate that case from the other ones just because the collision happened a little, a short distance away. All the parties in this case, including Liesel, all the plaintiffs, the numerous parties, all assert the same theory against my client, which is that their employees negligently entrusted a vehicle to Mr. Saipov. So when in view of that, I don't see how
the court could conclude that the lower court abused its discretion in saying, look, it's just going to be a lot easier to have all these cases consolidated for the purposes of, by the way, only discovery, because the order did explicitly leave open the option that there could be a motion for severance by Liesel at the time of trial. So unless the court has any further questions, I'll rest on my brief.
I think we don't have any, so thank you very much. I'll give you a couple minutes for rebuttal. Anything you want to add?
Thank you, Your Honor. So, yeah, just briefly, the solution again of waiting until the end of discovery to then determine that yes, Liesel, is entitled to a separate litigation. That already all of the prejudice would have already been borne by Liesel at that point of having delayed its case significantly and had to participate in all these other actions. And I don't believe there is any risk of
Counsel,
yes.
you keep saying that you have to participate in all these other actions, but isn't it a fact that the only thing you're interested with respect to the other actions is maybe discovery from the defendants in the other action? Because you don't care about the plaintiffs in the other action, do you?
Not to my knowledge, I can't imagine they weren't on the bus. So I can't
the discovery from the defendants in the other actions is one set of discovery, which means one deposition sitting, which means streamlining discovery in all of the 18 cases if you're consolidated.
But I would posit that the streamlining could occur with severance where we could, because I'm sure these defendants will not produce their witness until the 24 other plaintiffs have been
But if
deposed.
it's severed, that means that they have to produce a witness twice. Once in the other 17 cases and then once in this separate case. Whereas if we consolidate, I mean, if we follow what the court did and affirm consolidation, then they only have to produce their witnesses once for the 18 cases.
I understand. I'm sorry to interrupt you. I understand that, Your Honor, but I think there could also be an accommodation where they could produce a witness for purposes of both of the cases. As I said, there should be no duplication, and even if they're separate, they're still giving sworn testimony, which should be absolutely consistent in another action, and the principles of judicial estoppel would protect
I fail to
against those
see the
inconsistencies.
prejudice and the abuse of discretion that you're arguing. I fail to see it.
I'm sorry, I missed the beginning of your question.
He said, I fail to see the prejudice and the abuse of the court's discretion in ordering the matters consolidated.
Sure. I do believe that entangling Liesel with all these other cases, which it is not a part of, is a substantial prejudice in terms of the time, length, and cost of this litigation. And also, it was raised in the brief, but the fact that the driver and the matron of the bus are plaintiffs in that lawsuit, and unlike perhaps a labor law case where a plaintiff may give testimony where his employer is a third-party defendant, my client is a direct defendant in this consolidated action. Those are the only two recipient witnesses from my company to this accident would be the most appropriate witnesses for my company. So again, the respondents claim that that's a trial issue and could be resolved with curative instructions, but I don't think that that's appropriate at this stage, and just it precludes me from having proper access to these witnesses and puts them in a precarious position of having to testify on both sides of the V in the same case.
Counsel, thank you very much, all of you. Have a nice afternoon.
Thank you very much.
Thank you. The next case for argument is Bowen versus Cone Resnick. All right, I think you just have a quick pro hac vice motion to make, right?
Correct, Your Honor. James Hayworth of Sidley Austin's New York office for the appellant Cone Resnick. I'd like to request my partner Bruce Braun, who's a member of the Illinois State Bar, present argument here today.
Okay, well, nice to see people coming from other places even to come to our court today. So, yes, the motion is granted, and you may
Thank you, Your Honor.
proceed. Thank you.
Thank you, Your Honor. It's an honor and a privilege to be here today, and it's actually nice to get out of Illinois and visit New York. Hopefully, things are returning back to normal more.
Sorry we couldn't have had nicer weather for you, but we'll try next
Oh, you know, from Illinois, we're not allowed to complain about the weather. I live in
That's
Chicago. If we complain about the weather, there's nothing else to talk about. New York courts have thoughtfully defined the limits on investor suits against auditors with investors who have no direct relationships with the independent auditor. New York courts have long recognized that investors cannot bring negligence-based claims against auditors unless they can meet the demanding near privity standard that this court announced, or the New York courts announced in Credit Alliance more than 35 years ago. These plaintiffs here first sued Cone Resnick in Massachusetts, alleging only negligence-based claims, negligence and malpractice claims. That case was dismissed for lack of personal jurisdiction.
Counsel, on a pleading motion,
Yes.
you have the report of the receiver. This, I can't pronounce her name, Sigonowski.
I believe it's Melanie Sigonowski.
Yeah, that is, you know, some of that's recited in the complaint. Why isn't that enough at the pleading stage to at least create an issue of fact, or not an issue of fact, to just plead scienter?
Well, it's clearly not enough, and I'll tell you why. First of all, there in New York for auditors, there's a demanding
yeah, we're familiar with the
plead scienter against auditors. That's
right.
Israeli bank case.
No, but as Justice Cardozo said in 1927, the assault on scienter is proceeding apace. So,
That's right.
You know, there are a lot of red flags here. There is the receiver's report. There is also the fact that you took over for the other hedge fund from BDO, a different auditor, and that they had issued this particular letter saying, we're worried here that there's not enough substantiation of the assets. So, in other words, again, pleading, you know, maybe at summary judgment you could prevail or a trial, but at this point, why isn't that enough?
Well, under CPLR
scienter.
3016B, when a cause of action is based in fraud, the circumstances constituting the wrong shall be stated in detail. And here, what that means is, proceeding under a red flags theory, the plaintiffs must identify facts with particularity that give rise to the inference that Cone Resnick ignored facts so obviously indicative of misconduct that it must have been aware of the wrongdoing and desirous of furthering it. That's the standard. So let me address the evidence.
I mean, there's also, I mean, maybe it's, maybe the development of the law isn't always 100% clear, but in the Hubakant versus Deloitte Touche case, which was, I guess, 18 years ago, our court said at the pleading stage of a fraud case against an accountant, that's what we have here, right?
Yep.
The plaintiff need not be able to make an evidentiary showing of exactly what the accountant knew as to falsehoods in the certified financial statements. So while I know they have to plead with as much particularity as they can get, the plaintiffs don't always know all the information. You know, people don't say, oh, look, I'm going to be fraudulent, and here's all the information that makes me fraudulent. And they have to do a little researching and finding it, so they, you know, there's a little bit of leeway.
Certainly, they have to do more than they did here, though, Your Honor. And in Hubagant, they did a lot more. They identified a private letter to the client that KPMG sent identifying various reportable conditions and significant deficiencies and then not reporting them. They took no actions to verify the deficiencies, and the auditor there performed due diligence for and actually financed some of the acquisitions that were substantially overvalued in the client's financial statements. Here, Justice Small, to turn to your question, the BDO letter. So BDO finds a material weakness. Material weaknesses are not uncommon with audits and auditors, and they're not evidence of fraud. Material weaknesses are identified to tell clients you need to improve your control structure to avoid having a misstatement. And what did BDO do? At the same time BDO issued its material weakness letter, it issued a clean opinion on the financial statements of the sister fund, PPVA. A clean opinion saying that the financial statements were correctly stated, free from material misstatement, whether due to error or fraud. They also sent a letter to the audit committee, and this is all on the record, saying we had no disagreements with management. Everything was resolved fine. So the BDO letter, which, by the way, was received after the audit here was complete, the allegation is, in the complaint is that Cone Resnick turned its attention to the PPVA audit, the 2014 PPVA audit, after it completed the last PPCO audit, and this is the PPCO audit. So the BDO letter itself is not a red flag. It's not a red flag at all. How could it be a red flag to Cone Resnick of possible fraud at this sister fund when BDO itself is saying the financial statements are free from material misstatement, whether caused by error or fraud? BDO did not find fraud. If BDO found fraud, it could not have issued an unqualified opinion.
Would you concede that there was the barrier between PPCO and PPVA was porous because both were controlled by Mr. Nordlicht?
No, I wouldn't agree with that at all, Your Honor. They're separate legal structures. They're separate legal funds. They have separate investors. They had separate auditors. Cone Resnick on one side and BDO on the other. They only had some commonality of investments.
Well, they're
They didn't
both,
have
and
similar
they're both
management.
managed by Platinum Partners, the sort of umbrella.
They had similar management, but they were separate legal entities. And they were treated as separate legal entities for all purposes, including for the audits. Now, let me turn to the Melanie Sigonowski declaration, because that's a significant element in their case. And I think the judge got it wrong below. I think he misunderstood what was happening with the Melanie Sigonowski affidavit. So she's the SEC receiver. She issues an affidavit or declaration in January of 2020, I believe. And the issue in her declaration is, should this stay in receivership, or it should go into bankruptcy? And she's saying, well, let me tell you some of the things I found in my investigation as of 2020. So with the exception of one thing, everything she notes in her declaration occurred in 2016, 2017, 2018, or 2019. Cone Resnick's last audit opinion on PPCO's financial statements was December 31st, 2014. So we argued below that with regard to one issue, which is a loan that I'll get to in a second, but notwithstanding one loan, all of these events happened afterwards. So unlike Hubagant, or Bear Stearns, the other case that the judge relied on below, those were facts known to the auditor at the time the auditor did its work, at the time the auditor issued its audit opinion. The Melanie Sigonowski facts that she found, that the fund was overvalued as of 2020, that certain things happened at the time she took over the receivership in 2017, aren't red flags to Cone Resnick when it's doing its audit work as of 12/31/14. That, with the exception of one loan that was repaid during the audit period, and it was disclosed in the financial statements. So a loan that's repaid and is disclosed in the financial statements can't be a red flag of fraud to an auditor. And why are these rules important? These rules are important because if you don't enforce pleading requirements against auditors at the pleading stage, then investors, all investors, whenever there's a failure of a fund, whenever there's a loss of investments, they'll always sue the auditor. In New York courts, and New York law has been clear, that's not the law in New York.
Okay. You'll have a few minutes on rebuttal, okay?
Thank you.
Thank you very much.
Good afternoon, Your Honors. My name is Glenn Lenahan with Oved and Oved LLP for plaintiffs. The lower court got this decision exactly correct. The lower court actually analyzed all of the allegations.
Counsel, can you pick up that one last thread about the intercompany loan? I know you say there was more than one loan. Do you also think that that loan should have been a red flag because it was repaid with assets that were overvalued? Am I correct about that?
It's a little bit more than that, Your Honor. It was more than one loan, and at paragraph 38 of the Honorable Melanie Sigonowski's declaration at the record on 948, she says, I also observed that the platinum investor funds were effectively commingled, beginning in or about 2014, so during the same time Cone Resnick is performing its audit work, and continuing through the commencement of the receivership. The Platinum Insiders effectuated repeat transfers of cash, booked as loans from PPCO and another fund, PPLO, to PPVA, in order to assuage growing liquidity issues developing at PPVA. The loans, plural, were recorded as being partly, but not fully, paid down by virtue of subsequent asset transfers, mostly of distressed private equity or debt positions at inflated valuations. This is the exact type of transaction that an audit should pick up and should note somewhere in there that this isn't a legitimate loan. This isn't a loan being made to purchase more securities or investments for a fund. This is a loan being improperly used to repay investor redemption request from another fund that constitutes commingling. And at this stage, at this pre-answer, pre-discovery stage, that alone would be enough. But that's not all we have here. We have much, much more than that. The receiver, and it's set forth at paragraph 215 of the complaint, said that there's no documentation to support the valuations, the inflated valuations that were put onto these level 3 assets. And the only documentation that existed, which was sparse, was of limited or questionable value. There was a dearth of independent analysis regarding the nature of each of Platinum's
Was she
investments.
opining about the relevant period, though, because your opponent says she was not?
Your Honor, with all due respect, Cone Resnick is distorting the allegations in this complaint. There's no temporal period put into the allegation from the receiver in paragraph 215. It says there was little to no documentation with respect to many of the investments. That's spanning the entire period. Everything that the receiver's talking about really is spanning the entire period. And especially right now at the pre-answer, pre-discovery stage, the pleadings that we have in here, based on the receiver's own statements, including at paragraph 71 of the complaint, where we allege that as determined by a court-appointed receiver for PPCO, by the end of 2013, the funds faced financial uncertainty brought about by, among other things, Platinum's systemic overvaluation of level 3 assets. The fact that there's no documentation at all is another independent basis to allow this to go forward. How can you sit there and say, all right, I'm going to audit these financial statements, let's look at the documents. Oh, there's no documents? Okay, I'll take your word for it, rubber stamp it.
Is that particularly concerning because PPCO's assets were, they weren't public, right?
Exactly, Your Honor.
They weren't very liquid, right?
That's correct, Your
They were
Honor.
sort of inherently hard to value.
This isn't IBM or Netflix where I can just type it into the computer and see what they're trading at today. These are, as you said, Your Honor, non-public, illiquid investments. And the fact that there's no documentation to support the valuation, that the inflated valuations that the receiver said were 300%, $500 million overinflated. That in and of itself is a clear red flag. But it's not only red flags that we allege. As the court below correctly found, we allege numerous violations of the generally accepted audit standards, including that Cone Resnick failed to test the reasonableness and assumptions and estimates employed by Platinum to determine asset values, failed to obtain reasonable assurance that the financial statements were free from material misstatement, failed to perform sufficient risk assessment procedures to provide a basis for the identification and assessment of risks of material misstatement in the financial statements, despite the fact that nearly all of their PPCO's assets, were level 3 assets with no observable market inputs. And it goes on and on. The fact that we have alleged all of these things before any discovery has even occurred, and to say that we have an alleged fraud with particularity, Your Honor, I very respectfully disagree with my adversary, and I believe Justice Ostrager analyzes properly under the correct law that governs in New York State courts. In fact, he relied on Hoobagin, which is directly on point. Now, my adversary tries to make much out of this by
One
saying...
thing that they criticized the trial court for was emphasizing the EMPs, the emphasis of matter.
Yes. Thank you, Your Honor, for bringing that up, because while we do believe that that argument is forfeited because it was not brought up in their moving papers and it was referenced only in passing on reply, what they actually say in these emphasis of matter is that such estimated values for these level 3 assets, which made up 103.2% of the partner's capital, such estimated values may not necessarily represent amounts that will be ultimately realized in the near term. I don't exactly know what that's supposed to disclaim, and at a minimum, that's an issue of fact. But even if that was it, it's directly contradicted by Note 4 in these in the audited financials. On record page 526, it states that the portfolio manager establishes valuation processes and procedures to ensure that the valuation techniques for investments that are categorized within level 3 of the fair value hierarchy are fair, consistent, and verifiable. It goes on to state that there's a valuation committee, and the purpose of that committee is to review the company's written valuation processes and procedures, and that the committee meets on a quarterly basis. Now, we have alleged, and as the court properly found, one of the red flags was that Platinum lacked written valuation policies, that Platinum's chief investment officer, Nordlick, exercised carte blanche authority over the valuation, that the valuation committee failed to maintain meeting minutes, calling into question whether those minutes actually occurred. And then, on page record site 528, the financial statements go on to say the company's other level 3 investment assets, investments have been valued using unadjusted net asset value of the investments. No unobservable inputs internally developed by the company have been applied to these investments. So they're admitting in the same audited financials that there's plenty of these investments that we didn't apply quote-unquote unobservable inputs to.
Okay, thank you very much. We'll hear from counsel. You have 2 minutes on rebuttal. I guess I have to remind people that the red light is supposed to mean that your time is up, and if we still have questions, we can ask them, but if you really need a short time afterwards, you're supposed to say, ask if it's okay, but it's not just like a suggestion, like, oh, look, the light turned red. So just reminding everybody that.
Guilty as charged.
Go ahead.
Very briefly, Justice Moulton, turn to your question about the loans and whether repaid loans with bad debt is a red flag. Here, if you look at record site 142 to 143 and 158, the business plan of this fund was to make exotic or speculative loans. So the fact that the loan was repaid using debt or investments can't be a red flag. Now, he says the commingling, he quoted Melanie Sigonowski, the commingling started in around 2014. The only loan in 2014 was the one that was disclosed and repaid during the period. Now, he also said that the no documentation at all, that Melanie Sigonowski's finding of no documentation at all covers the time period. It doesn't. She said, when I came in as the receiver, I found limited documentation. She didn't say no documentation at all. She said, I found Platinum's ordinary course documents, but I didn't find other things. Now, whether there are documents in late 2017 tells you nothing about whether there are documents in 2014, particularly if you have management that allegedly is committing fraud. It has some motive to get rid of the documents afterwards. One last thing. I know my light's going to go off quickly, so one last thing. You shouldn't look at this case in isolation in determining whether they've met their pleading standard for fraud. They've had a tremendous amount of discovery. You had the Melanie Sigonowski investigation, all of her work in the SEC receivership. There was a months-long criminal trial in the Eastern District of New York, and that record is publicly available. They've had a tremendous amount of discovery already, and this is all they've come up with. I'm going to give back some of my time that I stole earlier. Thank you.
That's okay. Thank you. Have a safe trip back to Chicago. Thank you all for coming in. Or Illinois. Okay, the next case for argument is Rivera versus O'Neill. Okay, counsel, you may start.
Thank you, Your Honor.
Afternoon.
Good afternoon. May it please the court. My name is John Tate. I represent the petitioner. We start off with the well-established rule that where the termination of a probationary employee may have been done due to improper basis, a petition should not be dismissed on the pleadings. This is a case where a petitioner was wrongfully terminated by the NYPD to frustrate his disability pension. Petitioner was employed.
Well, we're pretty familiar with the facts, as you probably noticed. But wasn't there an issue here that your client had certain problems and he was on terminate? He wasn't just a probationary employee, he was on termination probation.
He was on, since 2017, he was on disciplinary probation.
Which is called termination probation, right?
Correct, Your Honor.
And then there was an automobile accident that occurred in a police vehicle that he did not report.
So in January of 2018, his motor vehicle had a blue scratch in it. There was no accident, there was no report, no one called it in. They went back and looked at a videotape, the dash cam, and he agreed when he was on a run on the FDR Drive, rushing to save someone, that his vehicle came in contact with a blue SUV. That happened in January. He was interviewed a week later, and then nothing happened. He was never brought up on charges until November, after he filed for disability. He continued working. He continued carrying his badge, carrying his shield, carrying his weapon. He was on limited duty due to a medical condition because of the disability that he would eventually file for.
Counsel, after the crash, there was an investigation, as you alluded, but he was questioned, correct?
That's right. Within a week later, he was questioned.
They showed him the dash cam.
That's correct.
At first, he said he didn't know if he was in the crash, and then they showed him the dash cam.
That's absolutely correct. Yes, Your Honor.
I have not seen that video, but is it so much that the collision was so slight that he could have forgotten it?
I'm sorry?
I'm sorry. Was the collision so slight, so insignificant, that he could have forgotten it?
It wasn't that he forgotten it. He didn't know they touched. And here's the key to this. And 11 months later is when he finds out that they bring these charges. Now, there's nothing in the record that says the investigation went on for 11 months. In fact, the petition states he had, or the records state that he had an interview a week later, and that was the end of it. However, in September, when he filed for accidental disability retirement, suddenly, out of nowhere, these charges appear. They don't serve it to him. They don't give it to him. They don't even put it into his file until after his termination.
Well, they didn't have to do any charges against him. They can fire him for virtually anything on termination probation, as long as it's not illegal.
Exactly, as long as it's not illegal, as long as it's not in bad faith, as long as it's not arbitrary or capricious. And it is undisputed that firing somebody for filing for disability pension is bad faith. It's arbitrary and it's capricious. This case, this court's own decision in Belmar is instructive on this very point. There, an NYPD officer was terminated and he was on probation. The court rejected the good faith excuses offered by the NYPD, and they said, no, because you could have terminated him 2 months before his accident, before he filed for disability. Because you left him on the force for 2 months, you can't go and use that as an excuse. In this case, it was over 13 months after that minor vehicle accident that petitioner was terminated, over 13 months later. As I said in my brief, the NYPD doesn't get a get-out-of-jail-free card that they can stick in their back pocket and pull it out as soon as someone files for accidental disability retirement. And that's what they...
Did the NYPD deny his disability pension hearing? Wasn't it denied before they fired him?
No, what happened was the medical review board made a recommendation that the pension board should deny it. His pension board hearing was going to be on April 10th. On April 5th, he was terminated, and therefore he never had the opportunity to go before the pension board with all his medical records, all his evidence, and get his disability pension. So then, I see my time is up.
All right, you have a few minutes for rebuttal, so we'll certainly be happy to hear from you a little bit more then. Thank you.
Thank you.
Okay, good afternoon.
Good afternoon, and may it please the court. My name is Wamika GB. I'm appearing on behalf of respondents. Appellant's case is solely based on the fact that he was terminated while in the process of applying for accident disability retirement. But this court's precedents, including cases cited by appellant, make it clear that that type of timing argument is insufficient to allege bad faith, especially given the clear good faith explanation for appellant's termination. And as your honors discussed already, this isn't a police officer who was under probation termination because he had gotten into a physical altercation with his girlfriend, public intoxication, which led to his arrest. So he pled guilty to those charges and knew that he could be terminated at any moment for any reason. Even given this second chance, he squandered it by getting into this accident. An appellant tries to underplay it, saying it's a minor traffic accident. But what's crucial here is that the police department determined that he misled the official investigators because he said he was unaware of the accident, but the investigators found that someone had turned off the dash cam right after the accident took place, as well as the fact that there was visible blue paint. So they determined it wasn't a case of a minor accident that he was unaware of, but that he was aware of it and misled the investigators. This is the case where I just want to highlight some of the Bellman, which is, I believe, which appellant just referred to, helps illustrate the weakness of the facts here. In that case, there was a probationary officer, completely distinct from what this officer here is. He's an officer who was put under this 1-year termination probation. And that officer had no history of wrongdoing, no trouble in his employment. He was fired 5 days after he applied for disability, and the rationale that the department offered was demonstrably disproven by the evidence. There was ample evidence that the good faith explanation was not valid. Here we have the absolutely contrary set of circumstances. Clear history of a police officer with repeated misconduct. In fact, not 5 days after he applied, but 6 months after he applied. What we have here is a vast administration turning slowly, we'll concede to that, but justly, to determine that a police officer was no longer fit to serve the public. And I just want to highlight
Counsel, with respect to the medical board denial of disability, I mean, that's often a process that goes back and forth, right? You know, they send it to the pension board, and the pension board says, have another look, and they sometimes can go back 3 or 4 times, right?
Right. Yes, Your Honor. So the stage, this April 10th date that appellant highlights, was actually just an opportunity for him to request to submit more evidence. He was a long ways away from actually achieving any type of approval, and in fact, he was disapproved. The cases we cite in our brief highlight that this court has found that purely timing evidence is insufficient to establish bad faith. And that's because these are institutions that actually they're not actually part of the same institution. As we laid out in our brief, the medical board is this independent group of physicians, and the pension board, again, labor unions, the city, they're not part of this risk management bureau, which made the decision to terminate the officer. So just because there's a timing question is insufficient. The cases that we point to in our brief, Castro and Sheridan, in those cases, the medical board had actually approved different pensions, and yet this court found that that timing evidence was insufficient. Here, there was no approval, and a really clear record of the police officer, the police department's intention to fire appellant based on his own misconduct. Unless there are any additional questions, our respondents will rest on their brief.
Thank you very much.
Thank you. I'd just like to quickly and briefly address a few of the allegations, or a few of the arguments. Castro, just cited by counsel, really held that the factual predicate on a motion to dismiss is what you look at to see if there's a basis for the allegations. That's the standard. This case arises on a motion to dismiss the petition. The court below was required to take the facts alleged in the petition to be true. It did not. When the allegations are ambiguous, the court was required to resolve the ambiguity in petitioner's favor. It did not. It looked beyond the pleadings, and it looked beyond documents And even we just heard just now facts that are not even in the petition or the motion to dismiss. No one's ever explained, the key to their whole defense is that it took 11 months investigating this vehicle accident for them to come to a conclusion. And yet no one's ever explained how that possibly could be so. What did anyone do for 11 months? They have a video, they talk to him, and he goes, yep, I see the video.
Well, you were talking about the burdens, but here we have an Article 78. Don't you have a very high burden to go with on an Article 78? Don't we have to determine whether or not the determination was arbitrary and capricious, and they're given a lot of deference?
Yeah, there is deference, and it's not a high burden, it's a high standard. And here we have a factual predicate, just like in Bellman, where the timing was used. They said, listen, if you file for disability and then sue right after, they terminate you, and they try to, even just like they did in Bellman, they try to come up with these excuses from a year ago. That's not justified. We don't have a burden to show a smoking gun document because none exists. No one ever is going to put that in an email. That's not our burden. And looking at the facts and the factual predicate alleged in the petition, clearly it shows that there's at least a sufficient enough question about whether this was a bad faith termination. This is the person who continued working until January, a year after the accident, with his gun, his badge. Thank you very much.
We will take a look at the papers again. Thank you both very much for coming in. Okay, and last but not least, CIP, GP versus Koplowitz. Okay, we have the appellant. Is that Mr. Harrison?
Yes, Your Honor.
Okay, Mr. Harrison, you may begin.
Good afternoon, and let me first thank you for leading the way and getting us back to normal here. It's good to be back in the court. May it please the court, I am David Harrison from Spiro Harrison for the plaintiff appellant cross appellee CIP. While there are seemingly numerous questions that arise from the briefing of the three parties on this appeal, the issues before the court on plaintiff's affirmative appeal are relatively simple. One, should plaintiff be allowed to assert quasi-contractual claims in the alternative where the defendants have directly challenged the enforceability of the contract at issue? And
Counsel,
two,
can we talk first about the contract claim, oral contract claim? Because, as you know, the defendants make a lot of the letter of intent. And they ask the question sort of rhetorically, why on earth would you agree to the language that exists on record page 250? That's the language that I'm sure you're prepared to talk about, saying that we're not having an agreement until we finalize our agreement, and then a lot of other things that make it sound like it's provisional. Why, if you had an oral agreement, would you then enter into a letter of intent like that, which seems to undermine the existence of the oral agreement?
Yes, Your Honor. So firstly, let me just address the entering into a letter of intent. Nobody entered into a letter of intent. There was a draft document that was circulated and unsigned. And it was
allegedly drafted by your client. I mean, do you disagree with that?
We don't disagree that it was circulated by our client, but it was requested by the defendant after the oral agreement had already been breached. So following the breach of the oral agreement, which was entered into in June of 2018, the breach occurred on May of 2019. In the days following of that breach, the parties got together and attempted to reconcile what was clearly already a dispute. And so as part of that reconciliation, an attempt to settle what was already a dispute, they drafted 6 points and put them into an LOI and circulated them. But upon the circulation of the LOI, and I think this is important and it's in the record, our client specifically indicated that it was a rough draft, that it was incomplete.
And wasn't there even one of the three parties that never got a copy of this letter of intent?
That's correct. When our client circulated the letter of intent to one of the defendants, he replied, quote, "It's garbage," and because it was garbage and incomplete, they agreed not to circulate it to the other defendant, who never saw it. It was never even considered by him. And another important point about the letter of intent is that the terms of the letter of intent, while consistent in some ways with the partnership agreement that was agreed upon in June of 2018, it is not identical. It doesn't mirror those terms. And the reason that's important is because it's a new agreement. And so the letter of intent, when it speaks to the language that states an intent to be bound until there are definitive agreements, it's specifically addressing the terms that are contained in that draft letter of intent, not the prior existing agreement that the parties already had agreed to. And one other point on the letter of intent, if I may. 2 days before the letter of intent was circulated, and I might just point out, the only value of the letter of intent is evidence of our client's intent, right, with regard to the entirety of the relationship. And just 2 days before that letter of intent was circulated, the same attorney who drafted that letter of intent stated in a letter to the defendants, the parties have a binding oral agreement. So at the very least, you have two competing statements about what the intent of the parties are. Now, we, of course, assert that the letter of intent reflects an entirely different agreement. It was a reconciliation and settlement of an already existing dispute. But if you consider it, you have an inconsistent statement just 2 days before. And as our brief lays out, for that reason, not only is it incomplete, not only is it inconsistent, but it was also specifically referenced as a draft. And so you can't consider it as documentary evidence under the CPLR, which specifically requires that it be utterly unassailable, that it utterly refute plaintiff's claims and prove that plaintiff has no claim because of the words that it contains. And that letter of intent is used as a defense in two ways. One, as you noted, Your Honor, plaintiff's breach of contract claim, but also plaintiff's promissory estoppel claim. And I just want to point out that the promissory estoppel claim, as well as plaintiff's other quasi-contractual claims, were dismissed because they were duplicative. And it's the CPLR 3014 clearly provides that plaintiffs may plead alternative theories of relief without having those.
I guess in this case you say because the issue of whether or not there is an existence of a contract is certainly quite an issue, that there would be this would be one of the cases where the court might allow the pleading and the alternative.
That's correct. When there's a bona fide
non-contractual claims.
Correct. When there's a bona fide dispute as to the existence of the contract, courts almost unanimously allow the parties to plead those alternative or quasi-contractual claims. And if I may address briefly plaintiff's unjust enrichment claim, the court dismissed this claim as violating the statute of frauds provision under General Obligations Law 5-701A10, pursuant to First Department case Snyder v. Brofman. But Snyder v. Brofman is a very different case than the one before the court. The provision that court relied upon states that an agreement for compensation of services rendered for the purpose of, quote, assisting in the negotiation or consummation of a business opportunity must be in writing. And in that case, the court found that the plaintiff's claim was based on devoted years of work to finding a business to acquire and causing an acquisition to take place. This is precisely what that statute of frauds provision is for. In our claim, plaintiffs have alleged a whole host of other services that they provided in connection with this business. Not only was there agreed upon role operations for which they built budgets, trained management and staff, developed sales techniques and strategies, they recruited new employees, and they implemented general operations strategies for not weeks, but for months. And in addition to that, they advised plaintiffs on acquiring new businesses, and they also helped build the business venture itself. Consistent with two cases, and I'll conclude after this one final statement, there's a Court of Appeals case, JFP Capital Advisors versus Lightstone Group, and a First Department case, Dorfman v. Refkin. We think this case is much more analogous to those two cases, and that's why the unjust enrichment claims should be upheld. Thank you.
Thank you very much. We'll hear from you at the end. Okay, Mr. Snyder?
Yes, nice to see you all, Your Honors. May it please the Court. Justice Ostrager dismissed 13 of the 14 claims. He got it 14th right. He should have dismissed the 14th claim, the oral contract claim. The letter of intent cannot be dismissed. It can't be ignored. It is a game stopper on the oral contract claim. That's what this court has held time and time again, because in this city, people come together, they talk about deals, they negotiate deals, and when one party wants to protect itself, smart lawyers do what this lawyer did. Time out. There is no deal. There will be no deal unless until we signed a definitive agreement. There are famous cases where Skadden Arps and Wachtell Lipton shake hands in a conference room. They pop champagne. They go out all night celebrating the deal. The deal falls apart and someone sues, and this court and every other court, Second Circuit, hold the same thing. You can't have it both ways. You can't protect yourself against liability by saying no deal unless we have a signed definitive agreement. And then when the negotiations fall apart and you don't want to use that as protection, you want to use it affirmatively as a sword and say, we had a deal. This court...
Well, what were they doing for that year before? I mean, I heard you tell that, I mean, I know you told that story downtown, but, and I get it, and a lot of times I would have to agree with you, but in this particular case, there was a lot of activity that went on before.
Yes, and that's every case. The Shuddy case is this court, the case, and in that case, the parties spent 2 years negotiating, working together. But one of the parties wrote, in case there's any question, until we have a deal that we both like, we're not bound to each other. And that's what happens. That was the Snyder v. Brofman case. I argued that case in the Court of Appeals. I argued it in this court. The same case, the same kitchen sink pleading with all these quasi-contract claims. The oral contract case didn't even make it up to the Court of Appeals. This court threw it out, and the plaintiff there didn't even bother to appeal it because it was the same kind of, nonsense claim where someone says, we have a deal, even though the parties said they didn't have a deal. And what happened in the Snyder v. Brofman case for 2 years, Edgar Brofman and Dick Snyder, two of the most powerful business people in the city, shared office space. They went to meetings. They went to they talked about buying a business for $2.5 billion for a year and a half. And this court said there's no oral contract claim, there's no promissory estoppel. And, by the way, the statute of frauds apply. So let me get back to the oral contract claim. Why did the plaintiff write that? That is the quintessential question. Why did his lawyer write it? Because he didn't like the way the negotiation was going. And he didn't want my client to say, we have a deal. So he said, we have no deal. And if this court upholds that claim on these facts, it will have to reverse its prior decisions that hold consistently when one party expresses an intent not to be bound, that is determinative and it kills any oral contract claim. Their response, and where Justice Ostrager got it wrong, respectfully, is he said there are no cases that hold that a subsequent writing that says that kills a prior oral agreement. That's not true at all. The Shuddy case, which we cite, and the First Department affirmed the dismissal of an oral joint venture claim based on the same kind of documentary evidence here, drafts, and those drafts said no one's bound until we have a signed written agreement. And in that case, it was 2 years, to Your Honor's question, 2 years after the parties were running around town and doing their business. And the lesson of this case and every other case is if you're going on spec without a deal, either get a deal or don't do it. But don't write to my client and say we have no deal, and then say we have a deal when you don't like the fact that we didn't reach a deal. And so the Shuddy case is dispositive, and in that case, again, 2 years later, there was a write-in that said we have no deal. And think about it just commonsensically. What sophisticated party and sophisticated lawyer would ever say we have no deal until there's a signed writing if they had a binding oral agreement? It absolutely makes no sense. The final point on the promissory estoppel is the reason that isn't an exception and it isn't an alternative claim is because this court has held that you need an unambiguous, clear, and unequivocal expression. I'm sorry, wrong notes. You need a clear and unambiguous promise. And why? Because before you're going to be able to circumvent contract claims and contracts, you need to have, and you're going into quasi-contract, you need something really clear and unambiguous, or else everyone's going to sue and say promissory estoppel. Here, this is the key point. The parties tried in vain for months to draft an agreement. They failed. The plaintiff and his lawyer said, uh-oh, we don't want to have a deal until we have a deal, and that letter of intent declares we have no deal without an assigned writing. How could there be a definite and clear promise if the plaintiff's own lawyer says we have no deal? So that's the Shuddy case also, where the court held, this court held, in language that is directly applicable here, that a email post-dating the alleged oral agreement, post-dating, some by weeks, some by many months, like in this case, quote, conclusively established that the parties intended to finalize their agreement in writing, which never materialized, inasmuch as negotiations had been ongoing and were eventually discontinued with plaintiff. That's this case, that's this court, that's the binding authority. And as for Snyder v. Brofman and why the statute of frauds is fatal to the unjust enrichment claim, that case is this case. Two people get together, in that case for a year and a half, here for about a year, to try to form a business enterprise, try to do business together, negotiate a business opportunity. They fail, and the court said that is fair. The Court of Appeals 9-0-7-0 held that the unjust enrichment claim cannot proceed because the statute of frauds bars it, because the nature of the services, that's the focus, for which he seeks compensation, relates directly to putting together the deal. The exception to that statute of frauds, which he tries to fall within, is where you do something outside of the deal. You try to recruit talent after the deal is done, or you develop products, and you say, it's not fair that I don't get paid for my services. But when the services have to deal with the formation of a business, as in the Brofman case and as in this case, the New York Court of Appeals held in Snyder that seeking compensation for services rendered in negotiating a business opportunity must be in writing. And there's a sound reason the legislature did that, and there's a sound reason that Judge Smith wrote that decision. Otherwise, this courthouse and the trial courts below would be flooded with litigation every time two counterparties come together to try to make a deal, negotiate a deal, and fail. Every case. You promised me
Well,
that.
I think in this case, a little bit, I mean, there was a little bit more done, and there was a lot more work. I mean, I'm not usually worried about the courthouse's gates being flooded, because cases end up being so specific on their facts.
But Judge, all of the cases, Snyder v. Brofman, a year and a half, they were sitting next to each other. They were going to the Four Seasons restaurant. They were pursuing, I know the deals, the Vivendi deal.
Well, they were pretty close to the Four Seasons.
Excuse me, Your Honor?
I said the Bronfmans were pretty close physically to the Four Seasons restaurant.
Yes, they were.
Now they can't go there anymore.
The point here, Your Honor,
And
is
here the allegations are a little more expansive as I read them in any event.
the point here is nothing happened here any different than in any other case, which is that sophisticated parties tried to make a deal, they couldn't make a deal. But this case is it's the plaintiff's own lawyer who wanted to protect his client against having a deal. Now says there is a deal. It really is.
Okay, you have I gave you
I just lost. I lost 50 seconds. I'm okay.
Oh, no, you didn't lose anything.
What did you lose?
You didn't lose anything, trust me. Okay, Ms. Dale, now you represent whom?
Eastmore Management.
Okay, so go ahead.
May it please the court. My name is Ashley Dale, and I represent Respondent Cross Appellant Eastmore Management. In the interest of time, I'm not going to re-argue any of the points made by Mr. Snyder. I just note that in our papers, we've joined in the respondent's brief and adopted their arguments as well. I'd like to make two brief additional points. First, the complaint does not adequately identify the parties to the alleged partnership agreement. The complaint states that the parties entered into a three-way partnership. However, the complaint lists 4 defendants, meaning that there's 5 potential partners to this alleged three-person partnership. The complaint does not make clear who these 3 partners are. Instead, it identifies different entities and different parties. For example, the complaint says that Hopkinson and Koplowitz formed the partnership through Thayer Street and Eastmore. Yet, it also says that its partners are Hopkinson and Koplowitz. Without alleging who the partners are, appellants cannot plead a breach of an oral partnership agreement. Second, the complaint does not adequately plead the terms of the alleged oral partnership agreement. For example, it does not include information regarding how the partnership would be governed or managed. It doesn't include information such as how operating decisions would be made. It doesn't include information how partners would be admitted or be terminated. And without such critical elements, appellant cannot show that they entered into any sort of partnership. We respectfully request that this court modify the lower court's decision and dismiss the second cause of action for breach of an alleged oral partnership. If there's no questions, I'll rest on the brief at this time.
Thank you very much, Ms. Dale. Okay, counsel, go ahead.
Thank you, Your Honors. I just have a couple of brief points. The first is that counsel has the facts all wrong with respect to the timeline of this oral partnership agreement. The agreement was formed in June of 2018, and as Your Honor noted, for the next 9 months to 12 months, they worked tirelessly on this business venture.
But I mean, I listened to what Mr. Snyder said, so, he, you know, it might just be what he said was good for his case, but are there cases that say that you can do that, you can work without a written agreement, do all this, and then if you never manage to enter into an agreement, then that's too bad, so sad, and you have to go away without anything?
The distinction is that, and his description of his cases are not entirely accurate, and I ask that you read them. Shuddy, for example, the court relied on a whole numerous documents to determine whether or not the parties intended to be bound. Not a single draft document related to a different agreement in which the parties specifically disclaimed its reliability. When our client said to the defendant, when he submitted it, this is a rough draft, what he effectively said was, do not rely on this document. And it was agreement between 3 parties. It was something they were supposed to work on together before they finalized it. And instead of doing that, the defendant said, quote, this is garbage, we're not using it. With respect to the timeline, after 9 months of working together, they had an oral agreement. They understood that the agreement was in place. They decided to memorialize it to writing. On the eve of this funding of this first acquisition, the primary asset, our client was sent an entirely different agreement, something that had no connection to the original agreement, and that's the breach. And after that breach, we were in a dispute. And when we were in a dispute, our counsel sent over an LOI of a different document, a compromise agreement, to try to repair this relationship that had been destroyed. In all of the cases that they cite, those documents, the correspondence, the draft agreements, the letters, they all relate to the core agreement that's trying to be enforced. That LOI relates to a different agreement. It's a compromise. It's a settlement of what already is an existing dispute because defendants had already breached the contract. And if I might just return to the unjust enrichment claim, Snyder v. Brofman is a very different case. Mr. Snyder in that case was claiming a finder's fee, and a finder's fee in the form of an equity percentage of the acquisition that he helped find and negotiate. We're not seeking compensation here for finding a business and helping to negotiate the acquisition. We're seeking compensation for building the business venture, training employees, recruiting staff, building marketing materials and investor documents. There's extensive amounts of work laid out in the complaint that are far beyond the contours of the statute of frauds in Snyder v. Brofman.
Okay, we will certainly look that over. Mr. Snyder, I think
Thank you very much.
Thank you very much. Yep. You do.
In the Shoddy case, First Department case, the parties worked 2 years. Lots of work, more work than here. Lots of meetings, massive joint effort. The First Department didn't care whether the parties worked days, months, or even years. That was 2 years, not 9 months. The point is that after 9 months here, the plaintiff's lawyer wrote a clear and definitive LOI, and he put a mark on the wall and a stake in the ground He said, I don't like what I'm seeing. There's no deal without a signed definitive agreement. Those are the magic words that this court relies on time and time again to bar oral contract claims. He talks about a single draft letter. That's like saying a single knife with fingerprints. It doesn't matter if it's a single draft letter. The draft letter is fatal. The fact that it's a draft, of course it's a draft. They never entered into a written agreement. But the draft expresses the clear intent of the plaintiff, which is inconsistent with the claim of an oral agreement. You can't have an oral agreement if you declare to the world and your contractual counterparty that you have no agreement. It makes no sense. And he even admits, counsel, that the lawyer after 9 months got a little frustrated and he sent this letter of intent, exactly my point, the stake in the ground with the magic language. And so that's it for the oral contract claim. He can't resuscitate what Judge Ostrager properly found was barred by the statute of frauds. And the Snyder Court of Appeals decision is an elegant decision, and it says labels don't matter. Call it a finder's fee, call it this, call it that. Let's look to the services at issue. And if they're covered by the statute of frauds, you're out. The services here that he wants to be compensated for the enrichment is services in connection with pursuing a business opportunity. And the legislature, in its wisdom, for real, said, that's too dangerous. We can't have everyone talking about a business opportunity have a claim. If they're pursuing a business opportunity, get it in writing. He pursued a business opportunity. He didn't get it in writing. And even more, he said there will be no deal without a signed writing. So 13th, 14th, great Judge Ostrager, good Justice Ostrager got it right. We respectfully submit you affirm the 13 dismissals and you reverse on the oral contract claim and dismiss the entire case. Thank you.